The petition is dismissed.
Effective agent for listing one urgent matter notice, tender matter. On tomorrow,
Why?
tender matter notice on.
Tender matter we've got not tomorrow. When was it last listed?
No, new,
Or new matter?
motion.
Okay. Okay.
Private to mention for a listing of two restriction matters.
Huh?
These two restrictions pertaining to matter contract of fulfillment. There's the last posted last year, June month.
Give it this.
Private matter. First, if I mention for listing, let's say, with petition 5254 for the 23, not from sir. Any date, sir.
New one. It's a new case.
Yes, sir.
Has it been listed before?
Most, yes, sir. Motion, admission, readmission.
Give it this.
Deputy. Right, please, your lordship, whatever has to mention for listing of a writ petition case that pertains to cattle tender settlement. So lordship, it has been 3 months since it was last listed.
Give it this.
With the consent of the other side, I'll take to mention item number 3. If this matter may be listed up to 3 weeks, we need to find out its right.
You're for whom?
Number 2, we'll file an affidavit in opposition in the
You want to file affidavit number 2. Who's for the other side?
APT state. We have taken the consent
Okay. Mr.
and more.
M?
More.
What about response number? Okay, Mr. M. Moore. Then I talk for the response number 2. Is granted
3 weeks.
3 weeks time to file affidavit in opposition. This is the matter of the case.
Yes, please, therefore, listing a tender matter notified tomorrow new matter. We have filed on 2 to 28.
Too much. Friday.
May I please your lordship? Your lordship, I beg to mention for listing of an urgent matter on 9th of February.
What is the urgency?
Your lordship, the matter has been pending since 2022. And it was.
And
supposed to be
the tender period is from which period to which period?
Your lordship, the last date of listing was,
What is the matter about, madam?
your lordship, the petitioner has challenged the workman representation in an execution case that is before the labor court.
Workman representation?
Yes, your lordship.
That is, there is a pending case before the labor court.
It's a pending case before the labor court and the petitioner has challenged the workman's representation.
No hurry, let's see.
May please, your lord. Lordship, with the consent from the other side, I beg to mention item number 20 of this.
Yes.
There may kindly be taken day after tomorrow or next Tuesday, your lord.
Why?
My senior Abhavata said that for observing her mother's Santa ceremony, she cannot come today. Lord.
Okay. The petitioner's counsel.
Petition.
The petitioner, adjournment prayer has been made on behalf of the petitioner's counsel.
Yep.
On account of him having to observe Shraddha. This is the matter after a week. I said after a week. Just give me 2 minutes, too much. Okay, next week give it this.
May I please, lordship, I beg to mention for listing matter for admission process. Is non-payment of contract to the lord.
Give a date, no hurry.
Section of 4 and 5 lordship. And for a respondent lordship, the records on even, but I have not brought to the lordship. 4 and 5.
First for the petitioner.
I will.
So what to do?
We get lordship after either Friday or Monday. Monday.
There's an interim order.
Is there any affidavit? No need.
Yes,
of
I have
affidavit.
filed affidavit.
You have filed?
Yes. The lordship may, if your record required, then only. Lordship can go.
Monday.
Huh?
Then
Lordship,
Monday.
lordship.
No, but what is the requirement? Why is the report?
Last time, one of the court asked to produce.
What is the requirement of a
No,
report?
okay, I filed it.
Huh?
I filed affidavit already
When did you file?
earlier. Not 2 months.
It's not in the report, I think. Just give me item. You wait. No, why? Let it come on its own turn. Wait, let it come on its own turn. Next.
So please, madam, I beg to mention item number 15, madam, with the concern of the other side, let the matter come after 2 weeks.
15.
Yes, sir.
What is the matter, Bob?
The matter is about the challenging the tender people.
They have challenged the terms of the tender, saying that the dealers have been given an advantage over their trucks. But
Yes.
so they don't have any urgency. Okay.
One of the conductor
They want it
was
after 2 weeks.
Okay.
But the IOC said one small prayer, but the date will be after 2 weeks.
Okay, there is no stay order, no? Okay, right. On the prayer for adjournment made by Mr.
Peter, sir.
B.
Peter.
B. Das, counsel for the petitioner. List the matter after 2 weeks.
You question from other side, item number 7 and 8. Come after 1 week. Better release to the suspension of fair price of license.
Huh?
Suspension of fair price of license.
So why should it be adjourned?
That we have some personal difficulty.
What is the personal difficulty?
Mr. B posting who is in this case, he has some personal difficulty. 7 and 8. After 1 week,
Why?
after 1 week.
Why?
Mr. B posting who is a
Where is he? He's in the court. He's in which court?
posting for
He's in another court.
he has not come.
Yeah.
That's the information.
Yeah, you have to go to some Bollywood acting class. You're not, yeah. eh, Your initial reaction showed that he is somewhere else. Huh? Okay, because they're very bad at acting, we'll give you grace marks to the 40 marks. 38 out of 100, we'll give you 2 marks extra. Okay, right. Huh? That's a similar matter. है ना? Similar matter. On the prayer for adjournment made on behalf of Mr. B. Kaushik,
8 I told you.
Huh?
8 I told you.
made on behalf of Mr. B. Kaushik by Mr. H. I. Chowdhury, learned counsel for the petitioner. This is the matter after a week.
By previous thoughts, if I take a mention for 2 weeks,
7 and 8, no? 7 and 8.
I take a mention for this of 2 respective thoughts for admission. The court meter matters are contextual matters and it is long pending.
Give it.
15 cycles.
The take of the tip. I see you are out of equation.
Yes,
My senior out of equation. It's a matter after.
no. Is there any admission on the part of the state respondent?
This is not a court matter. Here, part of the thing is that here is a dispute.
Ah,
2 people are claiming, my lord, that they were partners. They did half work and now both are, my lord.
The thing is that the entire contract has been allocated to Messrs. Moinul Haq Enterprise. Okay,
I know.
Moinul Haq.
Okay, the petitioner.
That is a petitioner. One of the partners has been filed his petition before his honorable court.
Okay,
The thing is that, after due to non-completions of the work,
Ah.
already 47% has been completed, the money has been released.
okay.
Now,
So 47% work completed and money received.
money released. Okay. Now, due to inabilities to perform the completion of the contract.
The remaining contract
Remaining contract,
has been given to somebody else.
on by virtue of the power of attorney, that is the response number 12, where I am representing.
Okay,
Yes.
okay, you are, who are you? You are
I
the,
am a power of attorney holder and completion of the work of the remaining work.
That is what, my lord, these are all dispute question of fact. No, we will keep money.
just a minute.
Then, thing is
So you were the person who completed the contract.
contract and by dint of the power of attorney holder and deed of agreement. And the power of attorney deed of partnership has exclusive right to the one of the partner to confer any, to give any authority to completion of work, to any part of the work on behalf of the firm. So I have lately,
So
received-
basically, you two are fighting over the money.
yes, basically I am fighting over the money, petitioner and the me.
When is your affidavit?
No, that is why I have received one of the completion certificate lately. I have to verify that. 1 week time may be granted to file this affidavit and
Let them find affidavit so that everything is in paper.
we will not.
Otherwise, my lord, the question of fact.
No, let that be in
Let me
writing.
clarify all this.
Problem to whom will tell the money? At the end of the day. Because in page 46, there is an application not to release the money by one of the parties. So, how we decide?
The thing is that we
There
are
are disputes.
already affidavit.
So let him find his affidavit.
Lordship, Lord. I will almost
Ah,
ready.
Okay, Mr.
H. Lord.
H. Barwa, learned counsel for the point number 12.
Twelve.
Anybody else wants to file affidavit?
Government has to respond, your Lord.
Why don't you make a short affidavit? Just say the fact
Affidavit, Lordship.
so that we can dispose it off.
Lordship.
My lord, actually, we are waiting for their affidavit, what they take, and then only my lord will come take the.
Okay.
They have to clarify.
Okay, Mr. Solar counsel for the point number 12 submits that he will file affidavit within
2 weeks, Lordship, 2 weeks.
in 2 weeks.
Lordship.
Accordingly, leave this matter on you for it.
Lordship.
Okay, right. The matter pertains to the claim by the petitioner for unpaid contractual bills amounting to rupees 24,04,943. Full stop. The counsel for the respondent number 12, on the other hand, submits that the petitioner had completed only 47% of the contract work. And as he could not complete the remaining part of the work, the respondent number 12 had been asked by another partner of the petitioner firm to complete the contract work. Correct, Mr. Counsel, by another partner of the petitioner
Yes.
firm. Full stop. Who is the other partner? What is his name?
But Jiten Nursery.
Comma, that is Jiten
Nursery. Responsible for
Narzari. No. You're the other partner.
No, I'm not the author. I'm the third person.
That's what.
I'm the third.
Who made you do the remaining portion of the work?
Number one partner.
What's his name?
Moinul Haq. Moinul Haq. Moinul Haq. There is 2 partners. Moinul Haq and Moinal Haq.
Okay, that one.
Moinul Haq surprised me.
Okay, no, this one is so Moinul Haq. How do you spell Moinul Haq? How do you spell Moinul Haq? Moinul Haq?
Spelling.
Spelling.
Sorry.
That is M-O-I. N-U-L.
Moinul Haq. Lordship, Moinul Haq, M-O-Y.
M-O-Y.
That is number one partner. Second partner, M-O-Y-N-A-L.
And the first one is M-O-Y.
N-U-L.
N-U-L. Okay, Moinul Haq. Full stop. Thus the next para, huh? Thus the claim for payment of bills has been made by the petitioner represented by the partner Moinal Haq, M-O-Y-N-A-L. Moinal Haq, and the respondent number 12,
Moinul Haq given.
comma, who has been authorized to complete the work by Moinul Haq, M-O-Y-N-U-L. Leaves the matter on date given. Huh?
With regard to non-payment of contractual bill, my lord, total bill value was 1,02,000, out of which my lord part payment of 34,625 was made, and remaining of 67,375 is pending, my lord. And the respondent has filed the affidavit they have admitted. My lord, it covers under a common order passed by this honorable court in a bunch of petition. My lord, may I submit that?
I think I've got it.
Yes, my lord.
I think I've got it.
So, my lord,
That in 4734,
Yes, my lord, my lord.
473.
Yes, my lord. The relevant portion
No,
is
no, I don't want.
156, my lord.
Leave it back.
Yes, my lord.
Here, central government and state, this is FMP method, FMP work process. So there is 70 and 30% share between central government and state government. The central part has not been paid till now. So Lordship,
So is the central government a party here?
Yes, my.
Ministry of
my-
Jal Chakri is a party.
no, Lordship.
Huh?
Central government is not a party here because that is with regard to their, because we have done the work of the state of Assam, my lord. So we have, my lord, the common order that is disposed of, my lord. In that also, my lord, the direction was not given to pay within a day. Under
Correct,
60
correct.
days. So my lord,
Only problem is, now if we are going to do the, if later what happens is contempt is necessary.
yes, my lord.
And what happens?
My lord, the thing is that this matter is a payment of.
Look, they will say, government will say, government of Assam will say, we have complied with the order. We have had it done through the assembly, everything. But now if central government is not paying, that too we cannot control.
That-
Then what happens?
Thing is that-
Why don't you make them a party? Then it becomes easy. I don't know. Otherwise,
that I can do. Because
we
my
can do
lord,
it, but
both of
it'll
the
be, it'll,
petitioners, my lord,
okay,
both of
okay,
the
if you want, we'll dispose it of in that line.
both of the petitioners.
Okay, right.
70, they have received their money.
Heard Ms. S.G. Barwa, learned counsel for the petition. Also heard Mr.
Shi Sharma.
C. Sharma, learned standing counsel.
I'm representing Mr. R.M. Das. He's the
Who is he? He's the counsel for what?
water resource.
Also heard Mr.
Shi Sharma.
C. Sharma, appearing on behalf of Mr. R.M. Sharma.
Das.
R.M. Das, learned standing counsel, Water Resource Department. The petitioner's case in brief is that para 3 of the writ petition. Next para. The petitioner, on completion of the work, submitted his bill amounting to rupees 1,02,000. Where have you said that some amount has
That
been
is for
paid?
the affidavit of the respondent in between the respondent affidavit matter. The affidavit filed by the respondent, they have given a
Okay.
statement showing
Page 20.
page
Lordship.
24, the paragraph and 20.
Despite representations made by the petitioner, the respondents did not clear the bills of the petition. Okay. Mr.
Shi Sharma.
C. Sharma, the learned counsel for the Water Resource Department, on the other hand, submits that the flood management program scheme in which the petitioner had a contract work, provided that both the central government and the state government were to provide funds in the ratio of,
70 to 30.
who is to give 70?
Central government.
Please look at your paragraph.
So, sorry.
In the ratio of 70 to 30. No, 30 to 70. 70 to 30. So central will give 70. State will give 70.
70.
So what have I said? Just read. Who is top first? Central government, whose name did we put first? Both the state government and central government were to provide funds in the ratio of 70 to 30%. 70 not 30%. However, due to non-receipt of central share funds, payments of the petitioner could not be cleared in time. Though the petitioner was issued a formal work order dated 15/11/2012 for rupees 1,02,000. Part payment of rupees 34,625 has already been made to the petitioner. The outstanding liability of rupees 67,375 will be paid to the petitioner only after receiving central funds from the Ministry of Jal Shakti Board, Government of India. I have one thing before this. Petitioner's counsel, let's say petitioner's counsel submit that a bunch of writ petitions where similar issues have been raised have been disposed of by an order of this court, by this court, by an order dated 27/9/22. In the lead case being WPC 4374.
No,
4734 /2021. He accordingly submits that the directions passed in the order dated 27/9/22 in WPC 4734 /2021 should also be issued in the present case. Then you write. Then you write next para. The counsel for the respondent also admits to the fact that similar cases have been disposed of by this court, the lead case being WPC 4734 /2021 by an order dated 27/9/2022. What's up? Next paragraph. On perusing the order dated 27/9/22 passed by the coordinate bench in WPC 4734 /2022, it is seen that certain directions were issued to both the state as well as the central government to release dues payable to the petition. As the present case is similar to the facts in WPC 4734 /2022. This writ petition is disposed of in terms of the direction passed in the order dated 27/9/2022 in WPC 4734 /2021. Which are as follows. You take, it is there. 1, 2, 3. Okay, para 8. Accordingly, the respondents are direct.
The problem is it is put in this line. Because if Jal Shakti won't release the fund, then we won't be able to pay it.
No, so we have given a direction as per it's a covered matter. It's a covered matter. Have you challenged this order passed by the coordinate bench? Then it's a covered matter. Accordingly, in view of the above, the respondents are directed to complete the entire process of payment of the unpaid contractual bills of rupees 67, 360.75 within a period of 4 months from the date of receipt of a copy of the form. The writ petition accordingly is 67 lakhs, 1,000 only, it's not even lakh.
But if they won't pay central government, then we won't be able to do it.
Then you make a challenge to the order of the single judge coordinate bench. That is still standing. I'm only reiterating what this court has said before. Then
Upliftment.
But if, I'll put a timing now. The good will be.
Huh?
Is a good will be.
This is a petition, my lord, for appointment of an arbitrator for certain disputes that have arisen between the respondents and myself, amounting to 2 crores 38 lakhs something odd thousand rupees. So,
what is
the
this? What
business-
is this? What is this contract?
my lord, there was a business agreement between the respondent two and myself to start a Baskin Robbins outlet in Guwahati. I am from Bangalore. He had come to Bangalore and we discussed with me, and then I provided the entire financing. So there was a shop opened and an outlet opened, and Gravitas, the parent company of Baskin Robbins in Bombay, I'm already a dealer for them in Bangalore. So on that basis, on the goodwill, they opened the outlet here. Then subsequently, my lord, there's been a diversion of funds, and I gave it, the business was given up.
Where is the contract agreement? Where is
My
the
lord,
agreement?
The agreement, my lord, would
Is
find
it
that
a
deed of partnership, which is at page 21 to 31.
so where is the arbitration clause?
My lord, that my lordship would find at page 29, clause 25. That was already seen by my lords earlier, and on that basis, notice was issued. So I've come under 8 and 11 of the Arbitration Act.
No. Now, so who is 1 and 3? Respondent
Respondent one
number one
is the company, my lord, the partnership made by us.
Okay.
3 is her present husband, who was also helping her with the business.
Who's present husband?
Respondent 2.
Respondent number 2's husband.
Correct.
But there is no agreement between the petitioner and the respondent number 3.
That's where we.
Helping her, that's a different thing.
That's where we
You have got a
come.
lot of workers also, they're helping you.
No, 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 madam. In this case, there's been a diversion of funds. There's been property bought in their home.
No, no, whatever it is,
Between
your
the flat
dispute.
lots. So I'm asking for a rendition. I asked for a rendition of account.
No, that may be.
Correct.
But your dispute is with the respondent number 2 only. It cannot be with
the arbitrator, and
only 1 point, only, it cannot be with 3.
let us not take this matter on at this stage in this. Let's go to the arbitrator. Arbitrator will knock them off and decide.
But then,
So entering into merits of the arbitration as per
no,
the
no, it's not a
arbitration
question of entering into arbitration.
clause- No, my lord. 2015 arbitration amendment.
I know.
My lordship knows that.
2015 is only with regard to section 12(1).
12,
Yes.
where the arbitrator is appointed.
Arbitrator is appointed, he cannot be an interested person
No,
in
no.
terms of Parkinson's easement.
The reason I raised that is because they had sent a notice to us asking for an arbitrator of their choice. That's why I came to the court.
Well, if it depends. If you're going to have 3 arbitrators.
No, we have
Uh,
one. I don't think they
let,
can
let-
afford.
Let us see what the arbitration clause says.
The clause, of course, talks about the umpire as well as the board of one arbitrator, one party each. In case of the disagreement to an umpire appointed by the board of arbitrators, or in that case, the default by the court, and the arbitration proceedings to be conducted. Sole arbitrator was not resorted to between the parties. But we have, if one reads the fourth line, my lord, legal representation whether raised during the continuance of a single arbitrator. So at the time when they made the deed of partnership, both parties actually were not looking to contest each other, but single arbitrator was thought. But since the business is to be in Guwahati, they possibly.
Anyway, three cannot come into the picture.
My lord, my lord. My lord is right on that.
Yes, please appear.
Lordship, in this case, I am appearing for no 1 and 2, Lordship. In this
1 and 2, very
one and
good.
two, Lordship. Lordship, what happened, Lordship, as per clause 25, Lordship,
Yes.
we have sent intimation to that petitioner proposing a name of an arbitrator from our side.
Ah.
So, but he has not, he's suppressing all these things, Lordship, he has signed his petition.
No, you also appoint one and let them appoint one each,
Yes,
the third arbitrator. That can be done.
Perhaps I
Then
misread
they shall
the amendment of
appoint a
2000.
third umpire.
After reading his notice, I went into the law, my lord, and I perhaps misread 2015. That's why I came to the court.
No,
But
you see,
neither of us could propose an arbitrator, according to what I.
so no, what is the issue is actually when there is a clause
Well,
in the agreement providing for arbitration, and the clause provides that only one arbitrator will be appointed
well,
by one of the parties concerned, say railways or GREF or whatever. It is in this context that the Supreme Court has held that the arbitrator cannot be an interested person,
well,
and accordingly he cannot be appointed as an arbitrator. And an interested person, if not an arbitrator, he also cannot appoint an arbitrator. So, supposing the arbitration clause provides that the general manager of some company or that the parties will appoint the arbitrator, that is also covered by 12(1). So it will not be appointed. Now,
That's
here is a case of him proposing his arbitrator, and you will propose your own arbitrator, and both of them will appoint the third arbitrator. That is one way. Or
going to my lordship's 2021 list of arbitrators provided in the court website. There are
No,
22.
now the issue is basically this. Does the clause 25 provide that there should be 3 arbitrators, or it
Single.
provides that only single arbitrator?
Single arbitrator.
Now, if it's 3 arbitrators, then the procedure followed by him, there's nothing wrong. You want an arbitrator. Either you accept or you don't accept.
I disagreed with him.
Then you will have your own arbitrator also. But if it's one and you cannot agree on the arbitrator, then the court will decide on the 11th.
That's why we come to my lord.
So let us see the clause 25. What does it say?
My lord.
That all disputes and questions in connections with these present.
All disputes and questions in connection with these present or to the partnership property rights, credit or effects or to any of the partnership account, business or transaction whatsoever arising between the parties hereto and or their legal representative, whether raised during the continuance of a single arbitrator, if the parties agree upon one, otherwise to the board of arbitrators, one to be appointed by each party, and in case of the disagreement to an umpire appointed by the said board of arbitrators, or in case of their default by the court, and the arbitration proceeding shall be conducted in the manner provided in the Arbitration Compensation Act 1996. Decision of the arbitration shall be final and binding on the party. So, the third portion, in case of default, arbitrator appointed by the court is what I'm saying.
One thing is very clear. Disputes will be referred to arbitration, but it's not clear whether it will be a single arbitrator or 3 arbitrators.
But my understanding, Lordship, I am proposing from my side. If
Ah.
those arbitrators are agreeable to my learned friend, that would be suffice.
No,
Otherwise,
interesting.
if he is listen to my proposal, so that he can
That subsequent part will come, Lokship.
Perhaps my friend has misunderstood my submission. We were on the point of interested arbitrator. No, that's what. No. Now you see, if there are three arbitrators, it's not a problem if they are interested arbitrator. Because in a way, because the third arbitrator will have to be appointed by two of them. And by the court. Now the issue is whether it's going to be a single arbitrator. Do you have any problem with having a single arbitrator to decide? Otherwise, if there are three arbitrators, your cost is going to go very high. Keep that in mind.
We go for a single arbitrator
appointed by the court. Yes,
Single arbitrator is better for both the parties.
correct. So now he's not agreeing to your thing.
Let him propose, Lokship.
No, we're leaving it to the court to appoint a single arbitrator.
Or we appoint, or we'll give you the list. Do you have the list? The 99. Just take out the list and show it to them. Let them appoint an arbitrator. Let them, you come to
There are
consensus.
as many as 7 retired district and session judges. There are 2 from the Supreme Court. I think.
No,
4
there are lots from the Supreme Court. There are 2 from the High Court.
Well, 2 from the High Court.
And they're district and session judges. You choose
6 or 7 from the
who you think will be impartial.
District Court. Mr. C.R. Sharma, retired judge of this court, my lord, is also.
I don't know. P.R. Sharma, this is H.N. Sharma.
Mr. C.R.
No,
Sharma
no.
is there, Mr. H.K. Sharma.
H.N. Sharma is there. H.K. Sharma is not there. 19,
HK
notification 99.
17th August, notification 90, I've got notification 61 of 17th August 2022 from this website.
No, it's notification number.
16.
No, I'm
61.
talking. No, 99. Look at 99. That's good. Yeah, mine is more up to date, I think.
No. I'm going on the website of this court.
Just straight to them. Okay. You all choose.
Subject to my friend's acceptance.
Okay. Okay, right.
Not in.
Heard Mr. P. N. Chaudhary, learned counsel for the petition. Also heard Mr. P. P. Datta, the learned counsel for the respondents number 1 and 2. No one appears for the respondent number 3. So office note dated 11. My office note dated 11/1/2024 states that AD card in connection with respondent number 3 has not been received by the register. Yes. Who?
Let me take.
Huh?
Let the matter be on next week, Lokship. We'll take instruction and.
Okay. Aaron, why next week?
Any day.
Tomorrow?
Tomorrow,
It's only a fixed name.
only fixing a name.
Day after tomorrow.
Day after tomorrow, okay. Right. Right. The petitioner has invoked section 11, no, has prayed for appointment of an arbitrator in terms of section 11(6) of the Arbitration and Conciliation Act, 1996, herein after referred to as the 1996 Act. The case of the petitioner is that he is a prominent businessman from South India who was interested in expanding his business in the state of Assam. Accordingly, the petitioner and the respondent number 2 formed a partnership in the name and style of
Respondent number 1.
MS Upasana Enterprises. Bracket respondent number 1. At Guwahati. Full stop. The respondent number 1 was to engage itself in the business of sale, purchase and manufacture of ice cream,
Ice cream, Baskin Robbins.
of ice cream under the
Trade name of Baskin Robbins.
under the trade name of Baskin Robbins. Baskin, huh? Robbin. This is very costly, this ice cream, very sweet also.
I have not had the pleasure.
It's very sweet. Quality and all are much better.
Good.
The petitioner's counsel submit that due to disputes that have arisen between the petitioner and the respondent number 2 in the running of the business in the name of the respondent number 1, comma, the petitioner would like to invoke the arbitration clause provided in the deed of partnership dated 21/5/2018 at clause 25, which provides for dispute resolution through arbitration under the 1996 Act. So, sir,
1996 Act as amended.
other than that, 1996 Act. So, sir. He submits that though the respondent number 2 had proposed an arbitrator to decide the dispute between the parties, comma, the petitioner is not acceptable to the proposal made by the respondent number 2. He also submits that the respondent number 3, who is the husband or wife,
Present
Will-
husband of the
who is the husband
respondent.
of the respondent number 2, was also what?
Working partner, uh,
Was also
working
working for
entity
the
with-
company,
with the respondent,
was also working for the
Respondent two.
respondent number 1,
respondent 1.
and as such should be a
That's very funny.
necessary party in the arbitration proceeding. Next. Mr. P.P. Datta, the learned counsel for the respondents number 1 and 2, submits that he has got no objection to an arbitrator being appointed by the court under section 11 of the 1996 Act. Correct? But submits that he would like to obtain instructions with regard to the appointment of an arbitrator under section 11 of the 1996 Act. Accordingly, leave this matter day after tomorrow.
On 8,
Then next para, you write, on considering the fact that the respondent number 3 was not a party to the partnership deed, comma, this court does not find, this court is out the prima facie view that there being no arbitration clause binding the respondent number 3 with the petition, it might not be proper for the respondent number 3 to be a part of the arbitration proceedings, comma, unless and until an arbitrator, comma, if appointed, decides the issue in terms of section 16. Section 16 of the arbitration
Okay.
act, comma, in as much as the jurisdiction of an arbitrator is provided in the section 16. I think so. For purposes of arbitral tribunal to rule on its own jurisdiction. 16. That's always the matter. Yeah.
On eighth,
So you just find out from your client. Look, now, one thing is sure, you have to have an arbitration. You have already proposed an arbitration. So you accept one of these persons.
regarding no objection, Lordship, I would have to take instruction.
I have not said no. I have not said no. What did I say? PP data? What did I say? No. No, you cut that. No, I said the next one, next sentence. He would like to obtain instructions. That's what I said. Okay. So this is the fact. That's what it says. Huh?
So the date is
That is what they want.
the date is fixed for 8th of February.
Day after tomorrow.
Okay. I mean, I think 4 and 5. Worship, this is not a matter pertains to settlement of the fishery by the FDC. So,
Fishery was for what period? How much? How many years?
7 years. Because by the under the process, some of the fisheries are allotted to them, my lord, AFDC, for the settlement. For that purpose, my lord, they have sorted a tender, my lord, tender of 1 of 2022, my lord.
Dated?
14/3/2022.
Huh?
It-
Where?
Two restitution has been filed, my lord. I am on restitution 4053
4053.
of 22. This is the first thing.
Let me see the tender. Where is the tender? I don't think you got the date right also.
14/3/2020.
Okay,
Page, my lord, 15.
okay.
This is the first tender, my lord. Betting tender for submission of bid. This is my lord 2A bid, my lord, technical and financial report. So we are concerned with, my lord, the item number 38 of the NIT, that is, my lord, Fulbari Anwar in Kachaki.
Then what happened?
Then, my lord, we have submitted our tender.
Then?
Then, my lord, there are 3 tenderers submitted their bid. Out of that, 1 was rejected, and 2 tenderers remain in the fray.
2 remain in the fray. Then?
Then they suddenly, according to their 10, my lord, they decided to retender it.
Why?
Why, my lord, said there is no tender, there is no much competition, or therefore my lord, decided to retender it. So they issued another tender 4 of 2022 in respect of the same fishery and
4 of 2022.
yes, my lord. Assailing that,
Dated?
my lord, that is all, my lord, 4 of 22, 3/6/22.
Where
It
is
is
that?
page number 39. That is page number 60.
Okay, then?
So then, my lord, when that NIT was issued, we put that NIT under challenge in this petition. So, my lord, not issue was issued. Then, my lord, this tender proceeding was stayed. We are given a liberty to file our
3-6
bid.
was state.
Yeah,
And you were given the liberty to participate.
participate.
Did you
We
participate?
did not participate.
Huh?
Not part- we
You did not participate. Then?
Right. So if then, my lord, this order, by that order, my lord, entire tender proceeding pertaining to code of 22 was stayed. That was a blanket order, not a fishery specific.
4 of 22.
That what my lordship will find at the next bid petition I have annexed. It is, my lord, 6411 of 8226 of 22. Another
Page.
page, my lord, will find. That page 39 of that bid petition. 8223.
Page 39.
Oh yes, page 13. Lordship will kindly have. We start from page 39.
Yes.
May I read Lordship? Page 39. It starts from page 40 is there.
No, no, where is the order?
Order is page 39, Lord. 41. It start at page 49. 41 is the operating part.
No, no, you said
Yeah.
that the subsequent tender,
Yes.
43636,
Yes,
36
my
was
lord.
stayed, correct?
Yes.
It was stayed.
Yes, stay. The stay order, Lordship will find it in the next writ petition, another writ petition, 8226 of 22. That's what I'm talking.
8226.
Of 22, another writ petition is there.
So that is not here.
Here, my lord, it should be there. Either, my lord, it came together. Both this.
8226.
Yes, my. That page for 39.
Yes.
We start from page 39, my lord.
Yes.
Now, Lordship will find hard so and so. The writ petition is directed against the retender notice of 6/6/22.
You said 36. It's 66.
Wrong written policy. It is of 3/6, code of 20. Issued by the AFDC for settlement of 37 Fulbari Alma fishery in district of Kashmir. The writ petition are hearing was of the three tenderer. We have submitted their bid in response to the original tender notice dated 14 of 22. That is tender number 1 of 22, in which I have participated. Issued in respect of the same fishery, after the technical bid were opened, two bidders, including the writ petition, are found to be technically successful. Whereas the technical bid of the third bidder was found to be defective, notwithstanding the same, the respondent had decided to go for retendering the same fishery. Mr. Good submitted so and so, nothing in the rules that mandate retender even if more than one bidder remains in the contract. In support of the argument, Mr. Bush relied upon the decision of this court in Devendra versus so and so. So, Mr. Sharma, learned standing counsel AFTC, on the other hand, produced a copy of the written instruction as well as the minutes of the meeting headed by the chairman AFTC, a result of which goes to show that since there are only two technically valid bidder, a decision was taken for rendering the for retendering. Accordingly, Mr. Sharma, first bid of both the technically valid bidders have not been opened, and therefore there is no question of any prejudice being caused to the petition. Having heard the submission of both the sides, next page minus page 41, in view of the matter, the court called for a further examination.
This order has been passed in the earlier writ petition also.
Yes.
So?
Then, my lord, since the date, last paragraph, my lord, since the last date of submission of tender is fixed tomorrow, that is on science address, order prejudice to the petitioner is granted liberty to submit the tender if to advise. However, the respondent shall not finalize the tender till returnable date. So, my lord, the tender code of 22, which I put to challenge, that was kept in abeyance, my lord. Then,
4 of
my lord,
22 is the 36.
3/6 months. So that entire tender proceeding was put in abeyance, kept in abeyance. Thereafter, my lord, they in respect of same fishery, they plotted another tender, in respect of same fishery. Despite of
Where
the
is that? Where is the tender?
yes, that, my lord, that is of my lord. That was, my lord, 13 of 22. That was challenge. Put to challenge
13 of?
22, my lord.
That is not here.
That is not a, because, my lord, why it is not there? Page 46 of that writ petition of 8226 of 22, page 46.
Yes.
Then, my lord, we file another writ petition assailing that.
No, no, this page 46
Yes, my lord.
is the tender notice of
13 of 22, dated 21 September 22. When the stay
so
order,
this has been challenged in 13 of 22.
yeah, that was challenged. That was challenged in, my lord, see another writ petition 6411 of 22. 6411 of 22.
6411 of 22.
Yes, my.
Which one was challenged in 6411? This short tender notice
Oh.
13 of 22.
Yes, my lord, 13 of 20.
6411 of 22 is
Yes, yes,
challenged.
yes.
Then
That's my lord. When we put that into challenge in that petition,
can
immediately
it
they
be?
withdrawn that tender. So
Huh?
that petition was disposed of.
you withdrew this 6411.
Because they withdraw that tender process.
The new tender issued on my lord deed
On 21/9/22 was withdrawn.
we are withdrawn. So therefore, the deed petition becomes issued plus that was withdrawn by. Now what remains is my lord, these two deed petitions. Thereafter, my lord,
No, what about this? Acha, this 13 of 22 is not tender. ठीक है. So,
then, yes, then my lord, they issued another tender.
where
That
is
is
that?
of 2022.
Where
In
is that?
respect of the same fishery. That was put to challenge in 8226 of 2020.
8226.
Yes, my lord.
Where is the tender notice?
Page 50, my lord. Page 50. Page 50, lord. That is in 8226 of 2022. In respect of same fishery.
Okay.
So, my lord, this two petition is two deed petition is now pending before.
Huh?
These two deed petitions are now pending before your lordship. Now,
So is this tender notice stayed or what?
this state also state, my lord.
Where is
8226
that?
also state.
Where is that order?
That is, my lord, on 26/22 lordship will file. In that state petition, 8226 of 2020.
26?
On 26/22, my lord. 26/202.
20th June?
28 June, my 22.
How can it be? This is of 17 December 22. How can the stay be before the tender?
Next, 8226 of 22.
Just a minute. Let him clarify his mix up.
No. It is on 21/12. Sorry, am I on 21/12? Okay, sorry, I am looking after that. 21/12/22.
Ah.
That NIT was statement. Now,
So, according to you, so there are two tenders according to you in the fray.
in the frame,
Now,
offered in the
so your tender is higher.
higher, my.
So you are expecting
Yes.
the settlement of the fishery with you.
Now, they might have filed a affidavit in 4053 of 2022, my.
Yes.
Now, in this affidavit, their stand is the same stand. Since my lord, only two tender are remain in the fray, technically valid tenderer, so we decided to retender. So if your lordship look into their affidavit, my lord, in 4053, take my lord, to their minute. It is a page number, my lord. Minute of 12/4/2022.
Page.
My lord, at 185. 185.
185?
185. In WPC 4053 of 2020.
185?
They are affidavit, not their affidavit. They filed an affidavit.
Page?
185 running page. According to what the copy they have submitted to us.
Page 43.
Yeah, this is page 185.
Okay, this is regarding minutes of the meeting, evaluation of technical bit.
So 12 April, my lord, 2022. Now lordship will find there, it's page number 186 is our feature. Item 3. Next page. Fulbari Anua Kata. The following three individual societies have submitted the bid documents for obtaining settlement of the Fulbari Anua Kata. Accordingly, evaluation of the technical bid has done. An observation was given as follows. Subhash Chandra so-and-so, Kajol Kumar Das, that is the petitioner before your lordship. And third is my lord's before Fulbari the Development Society. So lordship, that third one was unsuccessful. Two successful bidder remain in the front. So in view of that context, my lord, that they my lord decided to retender. So
What was the bid amount?
my lord, the bid amount lordship will award, bid amount lordship will fine from 4053. I'll just take a lot of open.
Not open.
It was not a two bid system. They are not supposed to.
No,
follow
they
it.
have
Oh.
open mail. They filed they have issued a notice in the public domain. I'll come to that. Let me submit my submission.
It's a two-bid system.
Yes, my lord.
What, technical bid and financial bid or what?
Let me go to 2411 order. 2411.
That is their order, my lord. I'll show from the record. I'll show from the record, lord. Let me submit, make my submission.
2411 order.
Make my submission. Make my submission.
2411, which year?
2023. But it look here, lordship. It was like a hard exam.
That is my lord, page 20. That is our big value. The 4G.
These cases are being listed very frequently, this case.
My learned friend was having operation, lord. So they took time, lord.
It is page 25 or 4053. That is our big
Page 25.
25. Lordship will value.
Yes.
Now, my lord, their reserve price was 11,50,000 per year. That will lordship will find at page 15 of that page. Page 15.
No, no, page 25 relates to what?
It's our offer.
1,41.
Yes, my lord.
Okay,
Then
then
and notice the whole deal. At page now, my lord, they say financial bid was not open by filing an affidavit. The affidavit was sought by the managing director of the corporation.
anyway, where is that page?
Page, my lord, 28. Lordship will kindly.
No, no, so 1,41 is your offer.
Yeah, offer.
And what is the offer of the other valid bidder?
We do not know, my lord. That is our bidder.
But you said that it was open.
The financial bid was open, my lord.
If it was open, if financial bid was open, you would have known the bid of the other side also.
Financial bid.
These are all open in the presence of each other.
My lord, look into page 20.
Okay, before going,
No, no, then.
reply one point, major one. Can you go to the my reply, lordship? My reply.
One at a time, Mr. Counsel. He is rejecting in the middle response. It is
Page 28, lordship. That is the notice published in the newspaper regarding opening of the financial bid.
So,
On 20,
so
Lordship
financial
kindly
bid,
note the date. Lordship kindly note the date. It is on 22/4/2022.
where are you getting? Okay, that okay.
22
It's written in pen.
here. That they will open the financial bid. Now they have filed an affidavit saying that on 15/2, we have taken a decision to retender. If that is so, how on 22/4/22 they could issue a my lord money notice for opening of the financial bid? Accordingly, the financial bid was opened.
I don't know. This is a type. This is a pen written. There's nothing, no signature, nothing.
Kindly see next page. Page 29. Lordship, it is in Smith. Notice that is published in Assam Tribune.
Unfortunately, there's no page, there's no date.
Yes, my lord. 22/4/2022, my lord. That is the date.
No, that is again written by pen.
Let them produce the record, your lordship, of 22/22.
No, no,
Then
that is one aspect.
Yes.
That is one aspect. Why can't they retender a tender?
my lord, there is a decision of this honorable court on the basis of which, my lord, the code of 22 not stay. Because when there is a true successful bidder, and it is not proved by the respondent that there is any, my lord, the understanding or there is any cartel.
What was
between
the,
bidder.
when it was last tendered, what was the amount tendered by the successful bidder in the last contract? The last time it was settled. The fishery, when it was last settled, what was the tender amount? Successful tenderer's amount? Quoted? Because this tender system also is sometimes, there's a lot of hanky-panky going on. Because one person can give 3-4 tenders. Once he's selected, he'll withdraw or he'll make it invalid so that the next one can come into the picture.
These things are
These things happens everywhere. So I want to know what is the amount of the tender, the bid amount given by the last successful tender. Because now is 1.41. What was the earlier when it was settled, the fishery was settled with some other person? What was the bid amount? What is the reason for only because two valid?
It
Yes, sir.
was not fine in his case, Lordship. It is not me. My Lordship kindly go to 2411 order of this court.
In which case, 22411, there are two
4053,
cases. Huh?
4053,
4053, 211,
2411, Lord.
2411, 2411, 22.
Yes.
Or
23.
23.
23, Lord.
There is no 2411.
Yes, it is there, Lordship. I in the website I got it. Lord.
Unfortunately, I've got the record with me. I don't know from where you're reading 2411.
It may be in the 826 note. 826.
Yes, yes.
Here, Lordship, in the last part, the affidavit we filed on 2811 in the state affidavit, it should also be indicated as to whether the financial vendor was open. Further to that, respondent shall also indicate as to whether the respondent have gone for fresh tender in respect of Rupai Bali bill, Kasar bill, as well as Baskandi Anua Kasar bill, where also there remain only two successful bidders after technical evaluation. Lordship, on that day, court has inquired us whether it was any malafide to go for only for them. There are only other two bids also. So we have stated that it is was for them. But in this case, my instruction
No,
is
no. So there was a fresh tender for this Rupai Bali bill also.
no, also.
And even for this bus kandi.
We have gone both of them also.
Huh?
Both of them also. In all the three bills, it is not that biasness was there.
Only on their case. Because
That was the court was inquired me
where is it? Where is this? Where have you stated this
in the affidavit.
affidavit? File in which case?
Court communicates
4053.
4053.
4053. Yes, where?
Para number 6. The department manager stating that the Rupai Valley bid and Barcelona written a notice for more number of bidder partially necessary. If any come and the minus or written a notice is placed before your honor regarding the participation of bidders. Next time, Lordship, they have we have more numbers of bidders participated in the next time, Lordship. There are number 6, and I have given the this technical minus also, Lordship. Annexer 2.
Show me where you have taken a decision that because there were only two bidders remaining, that you had asked for a retender
Lordship,
of this Rupai bill and this bus kandi.
Lordship.
You bring the records, no point in wasting time.
Okay.
Mr.
P. Sharma.
P. Sharma, learned counsel for the respondent, shall produce the records. When?
Monday of Friday.
Tuesday. Tuesday. Huh?
First, Wednesday lot. Wednesday only then. Thursday then.
Thursday.
Okay. All of the interim order is.
Interim order to continue till the next week. You bring the record. You show me the document by which it has been stated that because there were only two tenderers left
Yes,
in those two.
Is there lot.
Where?
Lot here in the affidavit. I'm just going for it. Here lot. This is in the affidavit. Kindly go to the full body Anua. This Baskani above that lot. Among the 5 bidders, 2 bidders have technically called 3 numbers of in the minus.
Please read.
Among above 5 bidders, 2 bidders have technically technically qualified and 3 numbers of Hardhan Das, Noren Das and Ganga Fishermen Corporation have not qualified technically due to non-submission of fisherman experience certificate and non-submission of balance sheet of society. Hence, due to insufficient number of qualified bidders, the committee recommended for a retender. It is in the affidavit notice.
And where is the retender notice?
Return the notice, no, I have given this,
You see, because I want to see the sequence.
Yes.
You see, this is now, when was that decision taken?
the decision was taken 12th of February 2022,
12 February 22,
April.
April. Now, subsequent to 12 April 22.
Yes.
Please show me the tender note.
This is proxy partial affidavit. In the affidavit also, technically which lot is here.
I'm not saying technical bid. I want to see the NIT, the tender.
It's not anecdote. I've given the minus one.
That is why I'm asking you for the tender. That's why I want the records. That's why the record will show everything. Next.
Nine.
Wait, all of the respondent number 5 have filed an affidavit, return affidavit to my
So one thing you just write in the earlier thing, just write. The stand of the respondents is that two other fisheries, no, the tender in respect of the two other fisheries have also been cancelled on account of their remaining two valid bidders. On account of there remaining only two valid bidders. Push up. He shall bring the record to. No, the council for the respondent shall bring the record to prove the same on the next day.
There is a legal code.
We have said interim order to continue all the things. That's it. Next.
Your object, the respondent number 5 have filed a return to my affidavit in reply,
Yes.
for which I pray 2 weeks time to file a reply, your lordship.
Why? What is your case?
Your lordship,
Not may have. The order dated 22nd December 2020.
Yeah.
Passed by this honorable court. We have raised the preliminary objection, my lord, in the reply. The
Yes,
report
yes, please for
maintained
admission hearing, yes. We are hearing it.
Yes.
What is your case?
your lordship, I am seeking for the payment of my contractual due from the respondent number 1. I'm basically seeking direction to the respondent number 1 to ensure that my payments are released. Now-
Why should the respondent number one pay to you? Who are you?
I am a supplier. I have supplied to a party. That
You,
party,
sir,
my
see-
contention is that he is a subcontractor. Now,
You are a subcontractor.
I'm not the I'm the supplier to the subcontractor.
You are a supplier to the subcontractor.
And the subcontractor being an agent of NSDCL, as per section 226 of the Indian Contract Act, the principal shall be liable for the act of the agent. They have an obligation to ensure
Just a minute, petitioner is supplier to
the
A subcontractor.
subcontractor.
Subcontractor, who is respondent number?
Number 6.
Respondent number 6.
The work was awarded by respondent number 1, 2, sorry,
Respondent number 2 to
respondent number 5.
respondent number 5. So, respondent number 2 and 5 have a contract agreement.
Yes,
Are you in that contract agreement?
no,
So, no contract agreement.
agreement between me and respondent number 1 and 5. But
How come one? Show
One-
me.
2, 1 is Union of India, that is, 2 is the NSDCL.
So, NHDCL and you, do you have any contract
No.
agreement? No
No.
contract agreement. So, you are 6.
I am with 6.
You're with 6 years.
I have supplied bitumen,
You have supplied to 6
yes,
and 6 has been subcontracted the work by 5
yeah,
and the contract has been given to 5 by Two.
And two, and
by
it's
2.
by two. And I'm relying on section 226 of the Indian Contract Act to say that,
226 of the Indian Contract Act.
yes,
Then you go to a court. You go to the,
yes.
You go to a civil
But
court.
your
There
lordship
is no
makes,
subcontract between the 6 and 5.
but I will show from the record.
Huh?
There is no subcontract between 5 and 6.
Between 5 and 6.
Yes.
No, even if there is subcontract,
Even if.
even if there is subcontract between 5 and 6,
Complete to respondent number 6,
huh,
he can claim and in the suit matter, there is no contract between.
but the issue is between him and 5.
Yes, it's a private. dispute.
No, between him and 6 only.
Yes.
Not even within 5.
Not
But my only
private
submission is
dispute
that
between them.
as a principal, they have an obligation to ensure that my legitimate.
You go to
interest-
civil court.
That's but it's an admitted amount.
No,
That's
maybe
what-
admitted. No, but there's no privity of contract between you.
But as a beneficiary, I'm entitled for, I have passed on a consideration. They have
Not
encouraged
under
their
2 to 6,
benefit.
Mr. Council, not under 2 to 6. No, nothing in part 3 has been valid. This is a purely private contractual relationship between you and the respondent
And
number 6.
respondent number 2, in their affidavit has said, they pray for a direction from this court, directing respondent number 5 to pay the amount. That is there in their
No, no,
affidavit.
they can say anything, but that
That's what-
that doesn't, that doesn't give you
Prayer
the
of
right.
the petition,
Huh?
if my lord may have the prayer of the petitioner, is directly against the respondent number 6, respondent number 5. 5.
To ensure,
No,
because
nothing against the NHIDCL. They have prayed for the legitimate use and for the NHIDCL.
It is basically a private dispute between you and respondent number 6. Even
And it's
5 is also not included.
Yeah. Paragraph 6.
Paragraph 6.
6 is 11 of the petition.
there's no denying of the fact that I have supplied you.
That is agreed.
That
You
that-
make your claim against the person to whom you have supplied it.
That is to the respondent number 6.
But your lordship, I understand your lordship, I have a tough case here. I understand it's a delay, but my only limited thing is that as a principal, would you
You
just
understand?
give it up? Because you have taken a protection
No,
under
but
your
then you
contract.
see, there are procedures. All cases do not come under 2 to 6. There's an alternative remedy
And
available.
your lordship, if the things are
It is
like,
not that you do not have, you don't want to take that alternative remedy because it is a long winding road. Which will see the light of day maybe after a couple of years.
Yes.
I understand your problem, but what to do? There is a procedure, otherwise
the
no
problem
one
is,
will file civil cases, everyone will come to the High Court under 2
your
to 6.
lordship, the cause of action arises in a place of not tasteful. These parties are from outside. Moment they go out, I have no scope to make any recovery, and my entire thing will be. That's,
Now, whose
that
fault is that?
If he
That
files a
is one.
suit, the notice will be issued to the respondent number 6. He can appear.
Yeah.
That, why he will not appear?
Your
You-
only,
Your case is basically between the panel.
and
He-
respondent
he-
number 6 has not
He will
even
go to
appeared
someone
before
from
this
the
court.
abroad also.
So,
There
that is a
procedure
different
in
issue,
the
that
CTC.
has nothing to do with that. They have appeared, not appeared, that is not the issue. The issue is whether you have got any contract with the respondent number.
But, your lordship, with regard to with subject to correction, privity of contract also has an exception.
Not under,
Except-
this is a pure contractual matter, payment of money. Please go to the civil court. As you know, you very well know that this, if you were on the other side, you would be,
Yes, yes.
you would be saying the same thing what you're saying. Unless you can show me the law that says otherwise.
That's why I'm trying to say it's an admitted amount.
That's what you're trying
I
to say.
tried,
You-
and in
you-
that,
But you have got to make that admitted amount, you've got to make that person, you've got to show their liability. There's no liability between them.
the liability is there, it's on record, it's
Yeah.
there on document. Now the question is
You
that.
see,
your-
for making an iPhone, the company that assembled will be taking from various different companies, various purposes.
Right.
Now, those persons will be taking the raw material from other places.
Yes.
So what will happen is, some person mining in Africa will say, I have supplied to Mr. A. He has supplied to C for making the iPhone in China. So iPhone people, they should pay me. Where is
The effect-
where is the contract
And
between
the
them?
minor effect would be that my entire payment has been stopped by the NHIDCL because of the pendency of this petition.
Anyway, I understand the problem. This is the problem going on everywhere. The
And
subcontractors,
NSDCL has been a party of, they accept the work of respondent number 6 without even impliedly and tacitly they approve a subcontract. Now they come up and say that we have not approved as per clause 4.2. On record, respondent,
I think they will say that the subcontractor is not allowed out.
they say,
No,
but
they
they
are not.
approved it fraudulently.
But in some cases, they say that subcontract is also not allowed. In some cases.
Here, subcontract is allowed, only they say respondent, just to show that I'm a stranger.
So, Constable, but what to do? Hands are tied. This is a writ court.
No
But if
subcontract minor is record.
let them verify. If
Then
they,
nothing, no, we can. That,
because ultimately they have accepted this good, this bitumen for the road. They have accepted it, they have
so
said,
what? For what they have accepted it? Because their contract is between 5 and 6. Not with you.
contract
with
may
you.
not be on the, only on the
No.
written. Mere
No.
factum of acceptance.
Okay, right. Heard Mr. D. Senapati, learned counsel for the petition. Also heard Mr. R.K. Talukdar for the respondents number 2 and 3.
Right.
Mr.
Anuj Kudesia.
Anuj Kudesia appears
five.
for the respondent number 5.
Yeah.
Acha, 2, 3, 4, huh? Correct. No one appears for the respondent number 6. However, no, not however, comma, though the proceedings of the Lawazima court dated 31/8/2023 states that service of notice upon the respondent number 6 has been completed. Full stop. Next paragraph. The grievance of the petitioner is that an amount of rupees 4,03,87,302 has been illegally withheld by the respondent number 6, which was to be paid to the petitioner for supplying bitumen to the respondent number 6. Full stop. The petitioner's next para. The petitioner's case in brief is that the respondent number 2 awarded the work, namely take this synopsis, sir. Namely,
Opening.
yes. Next para. The respondent number 6 thereafter issued no, requested supply of bitumen with the petitioner for using the same for his subcontract work. system. The petitioner accordingly transported and supplied bitumen to the respondent number 6 at his work site from November 2020 to September 2020. Though the respondent number 6 made payments of some amount of money for the supply of bitumen, an amount of rupees 4,03,87, 602 has not been paid by the respondent number 6. To the petition. Next para. The petitioner's counsel submits that the petitioner, by letter dated 12/5/2023, requested the respondents number 3 and 4 to look into the matter. However, the respondents number 3 and 4 have not taken any step to ensure payment of the unpaid bills of the petitioner by the respondent number 6. The petitioner's counsel accordingly submits that a direction should be issued to the respondents number 2 to 4 bracket National Highway and Infrastructure Development Corporation Limited to ensure that the legitimate dues of the petitioner are paid from the dues that will be payable to the respondent number 5 and 6. Next. The learned counsels for the respondents, on the other hand, submit that the claim for non-payment of dues made by the petition is basically against the respondent number 5 and 6, who are private respondents. They submit that NHIDCL has nothing to do with the non-payment of dues of the petition by the respondent number 6.
Developer, can I just remark something? Developer may not go into the merit and because this grants me liberty to go for the civil court.
You withdraw with liberty to approach the civil court, will allow? Because if I'm going to pass an order, I've got to give a reason, I've got to give some
No,
reason
that
for
is,
why I'm
it
dismissing.
can it be just it's a private dispute and therefore parties.
But supposing you go to division bench and say, I have to make sure that my order
No,
is
but
not set aside.
if your lordship goes into the issue of subcontract and all,
in that area,
You withdraw?
then I'll have, again, later on, I might have some problems there in civil court, going to meet those things. That's why,
Those issues.
because whether NSDCL is bound or not, or what the entire gamut of the contract thing. Therefore, if it can be just limited.
But
to-
I'd have to give some reason, no?
No, that since it's a, your lordship has already.
Deciding the civil suit.
Huh?
These finding given by your lordship.
There is observations and findings.
So if your lordship is saying, or has already recorded that it's the amount is against the private respondent and nothing. Considering the fact that the prima facie it appears against the private sake,
They will try.
not any other.
No, you'll, in the division, so I don't know, but I've got to make sure that at least the division bench will understand that this is a reason
No,
order.
only on the issue of that prima facie, it appears that the amount due is against private sake, it's a private layer and the.
You give you say that, I cannot, you cannot tell me how to.
No, I,
Unless you are going to-
your lordship, I will take back my, it's just a gun.
I understand, but the problem is supposing you challenge this order in the DB, then what happens?
Because your lordship is right, that being if it's in a private domain, private contractual matter, your lordship has the discretion either to exercise or not to exercise.
Okay, anyway, right, what have I said? Come on, as there is no privity of contract.
I try to establish there is privity of contract, but anyway,
That's why you're going to do it anyway.
Even then, if he has any payment due against that, due against the respondent number 6.
As there's no privity of contract between NHIDCL and the petition. Similarly, there does not appear to be any privity of contract between the respondent number 5 and the petition. No document has been shown by the petitioner to show that the respondents number 2 to 5 were bound by the supply order by the supply of bitumen given by the petitioner to the respondent number 6. The issue raised by the petitioner hearing is only a private contract based between, involving the petitioner and the respondent number 6. Yes,
your lordship, I think I will withdraw. Just because no documents, there are documents. If I have to go into that.
no, documents between you and the respondent number 5.
They have accepted those supplies, they have put it in the road.
No, that is a different thing.
But
No, that is a different thing.
No
your lordship
agreement.
going
That
to
is-
the
there-
low road,
No, there is not,
no agreement.
there's no agreement. They use it, so what? That way, though, supposing, you see, that way, you buy furniture, the wood comes from forest somewhere.
Yes.
Now, can that person who cut the tree say that you have bought that furniture? It came from my forest, I cut the tree, you have used it.
is it
Now
possible
you have got to pay
That too.
for that, the shop which
No,
did
no,
not
no,
pay.
your lordship. Respond
It's
is,
a remote.
Anyway, leaving that aside,
that,
you want to withdraw, we allow you to withdraw.
can I just take 10 minutes time to take an instruction, inform my client before I withdraw?
Okay.
Because otherwise, that.
ठीक है, okay. 10 minutes.
Therefore,
May I please, Your Lordship? Lordship, here, the petitioner, we entered into an agreement with the bank to repay the outstanding loan in certain installments. And in between, there were for father, I would like to pay for 3 weeks time to 5 lakh. Already entered to file transfer. Because there was a difference in the.
Huh?
There's a difference in the demand notice as per the, this, what compromise did.
There is no compromise, deed. Where is the compromise? deed?
It was their stand. It was compromise.
This is the bank document.
No, no, you see, what has happened is you have given him an installment plan. Installment plan was given.
Yes.
And, but you have not followed the installment plan.
That is why we have paid the interest over there. 42 lakh was paid as an interest. While meeting while paying the entire installment, we have paid the interest on the delayed payment that has been made from our side.
So basically, his grievance is that the notice, legal demand notice, does not make a mention of the installment plan and the amount paid.
Yes.
That is the grievance.
And
So I
after
need
payment of the
3 weeks.
entire amount,
So that's why I pay for 3 weeks time to find a copy of it regarding this.
To what effect?
Regarding the demand notice, whether, the,
Why 3 weeks? By the time his interest will shoot up all the time. You see, because of him having a problem in repaying the amount, the bank had made an installment plan by which he would have to give money every month, a certain amount of money. Now, him being unable to follow that installment plan, he defaulted.
Yes.
However, he has apparently paid interest. We do not know. On the installment plan, the amount to be paid every month. The above being said, you have issued a demand notice to him while he's saying that he has got a liability of a few lakhs only.
Yes.
You have issued a demand notice to him saying that he has to pay 2 crores, something, I think.
Yes,
है ना?
yes.
And you have not made a mention in your demand notice that there was an installment plan made by you. And the amount already paid by him as per the installment plan. So he's saying, how can you make a demand notice without making a mention of your installment plan and the amount paid? That's all. What is so difficult?
that in that case, also this matter may come up next week about, because the case counsel is Mr. M. Sharma, he's president bank. That is
M. Sharma. That senior counsel? No,
No,
that old, that's different. Huh?
Then it may be taken up next week.
But will affidavit be required?
they can, the instruction will do whether
Instructions,
they
I
have
think,
received the
will-
amount or
yeah,
not from
yeah.
our side.
Okay, right. Mr. S. Deka appearing on behalf of Mr. M. Sharma, prays that the matter may be listed after review. Good stuff. The grievance of the petitioner is that the repayment of dues by the petitioner was allowed by the bank by way of an installment plan made on 29/7/22. The petitioner's case is that though he did not follow the installment plan in toto due to some difficulties, the outstanding balance payable by the petitioner to the bank was how much?
So total it was 2 crore 77 lakh.
No, that is different. After payment
After payment, now we have paid the entire amount. Nothing left.
was no, you have not paid the entire amount. You're also not clear of the fact.
No, Lordship, while at the time of filing this writ petition,
How much?
we have paid total.
How much was the balance payable
Now, as on today,
at the time of filing of the writ petition?
by that time we have paid 1 crore 56,000, 56 lakhs.
That much I know. I'm
Yes.
saying payable,
Payable is
Payable.
not paid. Payable. There's a difference in
Yes.
the words.
2.77 lakh.
Mr. Counsel, that is not the amount.
remaining outstanding, that is 16 lakhs
16 lakhs.
as para 12.
16 lakhs.
Sorry, page 3.
16 lakhs. Full stop. However, the bank, without mentioning the installment plan that had been approved by the bank and the fact that the petitioner had paid most of the dues, has now demanded rupees 2,18.
Yes.
Is it?
Yes, Lord.
2.2, 74,739.36. By the legal demand notice. On the prayer of Mr. B. Deka,
Yes, sir.
S. Deka. Release the matter after review.
It may be fixed, Lord.
Huh?
It may be
15.
fixed.
Relative have instruction to withdraw.
Right, heard census also all done, okay, yeah. And
With
Mr.
liberty here.
No liberty, no liberty. Mr. D. Senapati, learned counsel for the petitioner, prays that he may be allowed to withdraw the writ petition with liberty to approach the appropriate forum. And the prayer of the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn, with liberty of faith. Liberty to approach the appropriate forum.
Yes, yes, sir. My appearance,
I have reflected, all your needs.
I'm good.
Okay, you're for whom? No, the Mr. Talu that you. The mid yes.
Yeah,
So I'm putting his name only. You're a senior? No.
Yes.
You're a senior counsel?
Yes.
Okay. Mr. Swenso, senior counsel, assisted by Mr.
Yeah. Grateful, man.
If item number 12 may be taken.
Huh?
12, 11 to 40, 12 may be taken.
Yes.
But in this case, on last occasion, my land senior only has produced records that I have not submitted. Now she has filed an affidavit on the attendees that my amount I have, my lord, given is exorbitant. It is
Exorbitant.
only that is there. 385. Now, my lord, on this issue, my lord, there is order of this honorable court.
Ah.
On this issue.
No. Let us see. Where is
My-
it exorbitant? Where is that? Let us see. Affidavit in opposition.
Yes,
Yes, ma'am.
yesterday I have filed.
I think I've got it.
Yes, sir.
Okay. I have not.
Page 39. Page 39, paragraph 3.
Yes.
As per record, the market settlement committee approved the bid values of 1, 2, 3 bidders as their bid were equivalent and bids are nearly more than 3 times of government schedule rate. As such, market settlement is not considered to invoke clause 11 of constitution of first step.
So basically, it's only because of exorbitant.
Now, my lord, kindly,
And your bid was number 1.
yes, my lord, I have the highest bid, tell it bidder. Now, clause 11, my lord, there is no restriction by. Page
Clause 11.
Clause 11, page 15 of my writ petition.
Page 15.
155. Last sentence.
Yeah.
Competent authority shall make settlement with the highest bidder if all necessary documents and government revenue are found in order. In case settlement is not made with the highest bidder, competent authority shall record reason in writing for their decision. The competent authority, before awarding all necessary inquiry, keeping in mind genuineness, eligibility of
Madam, you are on the wrong page, I think.
Right.
No. Come to page 15. Your tender notice clause,
I have seen,
clause 11.
I have seen it. I am seeing the 11, the 16 also, Lord.
The tender document itself provides the rate which shall be charged from petty vendor. By the
Page.
page 16 also, continue from page 15.
There are two, the tender
If
document.
there is a high rate lot, it will, but the four
Correct.
petty vendor.
No, my lord.
But then you have got to show
But in
how his,
page 16,
I know.
The tender document itself provide the rate which shall be charged from petty vendors by successful bidders, and no one shall charge a single penny more than the prescribed rate, posing burden to the poor vendors, my lord. The successful bidder he cannot charge, my lord. Should be as per government rate, my lord. Now, on this issue, my lord, there is order of this honorable court. In last settlement, by virtue of this court order, my lord, I got the settlement, my lord. This plea was there also, my lord. And that was dealt by this honorable court. I have annexed that order also. And main case is, my lord,
Where is that order?
my lord. It starts from page 31 and relevant, my lord. In para 11, my lord, page 35.
Page 35.
35, my para 11. The impugned order dated currently is accompanied by direction from the petitioner to the competent authority of the respective clause to go ahead with the allotment of the market. Pursuant to the state communication, the allotment order has been done in favor of transfer through a temporary basis. Neither of the aforesaid to communication contains a statement as to why valid was not accepted. In course of argument, the learned counsel for the respondent has tried to make out a case that the rate of the petitioner was an exorbitant and one, and as a result of which the key vendor would be put to distress. However, this argument is belied. Condition attached to clause itself as that such rates are fixed and cannot be deviated from. That is there in clause 11. Is there, my lord? That the executor cannot charge himself. It is there.
Cannot charge extra.
They cannot charge. Now, my lord, on this issue, similar line, my lord, this honorable court's order of 2015 is there, my lord. I will produce, my lord. If the respondent wanted to put a ceiling on the maximum amount that can be quoted by a tenderer, then such decision and or ceiling ought to have been notified in clear terms to the bidder. Even assuming that the state exercise could not be carried out for any valid reason before submission of the bid, fairness demands that highest bidder ought to have been given an opportunity to reduce their price so as to match the condition imposed by resolution turns the minute meeting date. There is no explanation as to why no such opportunity was given to the highest bidder. On the contrary, what has done is that the highest bidder in both the cases have been completely eliminated from the process after opening bids by employing newly evaluation criteria. And this issue already decided in earlier my petition, my lord, which I have produced your only. Now, their apprehension is that if I settlement is making a higher rate, I may charge more. That shall be restricted by their own clause, my lord. That as per government rate, one has to take it back.
So, madam, you see, the thing is this. I have no price. He has given a high price. So your apprehension appears that he may charge more than the prescribed rate. But until he charges them, how can you just deny him on speculation without being sure of the set fact? How can you? As and when he charges extra, he cancel his tender, the settlement. Anna. Yes, where is the judgment?
P4.
Okay, right. Heard Mr. J. Laskar for the petitioner. For the petitioner. For petitioner. Also heard Ms. R.B. Bora, the learned standing counsel for the BTC.
PTC. 1, 2, and
BTC 1, 2, and 4. 1, 2, 3, 4. One to three, 1 to 4. 1 to 4, huh? No one appears for the respondent number 5. Who is respondent number 5?
He's a settlement holder. Service completed, my lord, so
Stop. Comma 2. The order dated 4/12/2023 passed by this court states that service of notice upon the respondent number 5 is deemed to be complete. As the next part. The petitioner's case is that order dated 3/8/23. Para second, third. Okay. Next one. The petitioner's counsel thus states that the settlement order dated 27/7/23 should be set aside. And the respondent should be directed to what is the settlement order? Is 3/7 or 27?
my lord, 27.
27. And in your prayer, you have said communication dated 3/7. What is this?
Oh, my lord, my communication date 3/7/27, approval was that.
Then
The,
it's
the petitioner that says that the approval order dated 3/7/23 and settlement order dated 27/7/23 should be set aside. To stop further, the respondent should be directed to settle the market with the petition. Next paragraph. Ms. R.B. Bora, the learned counsel for the response number 1 to 4, submits that the market settlement committee disapproved the bid value of the first, second, and third bidders, as their bids were exorbitant and the bids were nearly more than 3 times the government scheduled. As such, the market settlement committee did not invoke section 11,
accepted.
did not
Clause
invoke
11.
Close 11,
clause 11 of the
tender.
tender notice dated 24/5/2023 and approved the selection of the respondent number 5 as the successful tender. I have heard the land for the party. As can be seen from the affidavit in opposition filed by the respondent's number. Blank
It is my opinion.
by the
Don't check.
by the BTC, by the BTC, comma. The bids of the bids of no, the three highest bids were disqualified on the ground that they were exorbitant. So while the first and second highest bidder have not made a challenge to their non-selection as successful bidders, the petitioner who had given the third highest bid has made a challenge to the same. Clause 11 of the tender notice dated 25/5/2020 states as follows. Huh? It is a bid for this. Next paragraph. A reading of the above clause 11 shows that settlement of the market has to be done with the highest bidder. If all necessary documents and government revenue are found in order. However, the competent authority has been given the liberty to keep in mind public interest as well as to the absurdity of the rates offered by intending tenderers, keeping in mind that no tenderer, no successful tenderer can charge a single penny from petty vendors than the prescribed rate made by the authorities. When they come to sell their crops and other goods in the market. In the present case, there is nothing to show that the petitioner would sell his, would charge higher rates than that prescribed by the authorities from the petty vendors who come to sell their crop and goods in the market. Further, there is no reserve price or upper ceiling made by the state respondent to show that the rate offered by the petitioner would result in the charging of rates beyond the prescribed rate made by the, beyond the rate prescribed by the authorities. Next paragraph. In the case of, where is that? Babu Ram Brahma versus the Bodoland Territorial Council and 5 others, WPC 4823/2022. Page 31, huh? This court by order dated 3/1/2020 had directed the respondent authorities to allot the market to the highest bidder, who was the petitioner in that case. The reason being, the reason for coming to the said decision was that in terms of the judgments of this court, in terms of judgment of the Supreme Court and this court, transparency and fairness were the hallmarks in matters of distribution of state largesse. And for contracts which fetch revenue, quantum was of paramount importance. Further, in the case of Tarun Bharali versus State of Assam and others, reported in 1991, 2 GLR 296, this court had laid down, had held that in matters of settlement, revenue to be earned by the state would play a major role. Next para. In the case of, what is this? What is this case number? In the case of Dash versus Dash, WPC 3476/2014. This court, by order dated 13/5, 2015. Had observed that if the state respondents wanted to put a ceiling on the maximum amount that can be quoted by a tenderer, then such a decision or ceiling ought to have been notified in clear terms to the bidders. Even assuming that the said exercise would not have been carried out for any valid reason before the submission of the bids, fairness demanded that the highest bidders ought to have been given an option to reduce their price so as to match the condition imposed by the resolution made by the authorities in the meeting minute. Next para. In the present case, also, the NIT pursuant to which the petitioner and others had taken, no, had participated in.
Then I say one thing on. Even then, we.
Maybe, but the others have not come to the point. They are not, they are not fighting for their rights. So those did not be considered. That will make clear.
Not, then you, then we fight, we have to ever fight with them.
No, we will say that we will say that since those persons have not come, they have waived their right. It is not a question of Operation Successful Patient Death. That does not apply here. They have not made a challenge. They are not interested. They have accepted. So what? We will clarify it. And this market rate is for 1 year. It's going to end Huh?
30 June is the last.
30 June. So nothing will happen. By the time they come,
Even high
Huh?
commission is also not correct.
so what? Better third than fifth or fourth. At least you'll get.
Then in that case, my submission will be recorded. Even though he is not, that's part time.
Okay, no problem. Then I will. We will do that. Don't worry. Okay, where are we? Does not contain any ceiling on the maximum amount that can be quoted by a tender. There is no reserve price fixed. Is there any reserve price? There was a reserve price. Reserve price is there.
My lord, the price is there, but there's no.
Reserve, full stop, huh? No, full stop. In view of the above, comma, this court is of the view that,
Is the price 65,
it-
65 standard paper. Page 4.
full stop. In the, full stop, though a reserve price of rupees 65,000.
No, my lord,
Settled-
schedule
this
rate is
settled rate.
3,96,755.
That's right. Though, schedule rate.
Settle
Mine.
rate is 65,000.
No.
Okay.
My lord, it is 3,96,000.
Where is that page?
Page 20, my lord, is the comparative statement.
20.
Lordship will see the schedule rate,
In tender form,
3 lakh. And in the tender page 14, my lord, cooperative weekly cattle market, 3,96,007.
No, in the NIT, anything,
in
Yes, my lord,
NIT
it is
lot.
there, page 14.
Huh?
Page 14, 14. Serial number 2, my, in the box. Cooperative weekly
3,96,000, 3,96,700.
750.
And how much did that other respondent number 5, what was this?
Lordship, he offered, 6,94,670. Private respondent,
6 lakhs?
94,670.
And
Yes,
you,
20.
and you,
I have offered 11,76,751.
6,000.
11,76,751.
Okay. So whatever I said. Yeah, participated in. First up. However, the schedule rate for the market had been fixed by the authority at rupees 3,96,750. While the respondent number 5 had quoted an amount of rupees 6,94,670. Not 670. Are you sure?
Yes, ma'am.
Yeah. 6,94,500.
500, yes, ma'am.
500. 500. 500. the petitioner had offered rupees 11,76,75. The only apprehension being what can be inferred as on date. No, what can be inferred is that there is an apprehension on the part of the respondent authorities that the petitioner, if selected, would be charging the vendors who sell their goods in the market rates beyond the prescribed rates made by the authority.
This is capital market.
Cattle market.
Yes.
Okay, you say the cattle, cattle. Wherever goods, I think is the cattle. This court is of the view that the said issue can always be verified by the authority at the time when the market is run by the settlement authority, unless some something is put down in writing to show that to show otherwise. However, in the present case, there is nothing to show as on date that the petitioner would be charging rates from the vendors beyond the prescribed. As such, this court is of the view that the state respondents would have to settle the bid with the highest bidder in terms of clause 11 of the NIT. Though the
Highest value bidder.
highest valid bidder. Though the petitioner is the third highest bidder in person to the NIT, the state respondents would have to consider the petitioner as the highest bidder as on date,
No,
in view of the fact that the first highest bidder and second highest bidder have not made a challenge to the selection of the respondent number 5 as the settlement holder of the market. Thus, the first and second highest bidder having waived their right to make a challenge to the selection of the respondent number 5 as the settlement holder of the market, the state respondents would have to consider the petitioner's bid to be the highest bid. In view of the reasons stated above, this court is of the view that the selection of the respondent number 5, the settlement of the market with the respondent number 5 being in violation of clause 11 of the NIT, the same is not sustainable in law and is accordingly set aside. Consequently, the impugned approval order dated
P720.
Huh?
P720.
P7
23.
23 and the settlement order dated
27/7/20.
27/7/23 are hereby set aside. Full stop. In view of the fact that the settlement period of the market is from 1st July 2023 to 30/6/2024, the settlement of the market for the period from till 30/6/2024 should be completed by the state respondents within a period of 1 week from the date of receipt of a copy of this order. Naturally,
Lordship.
uh, Then, you also right? The respondent authority shall also take steps to refund the appropriate amount of deposit made by the respondent number 5 for running the market.
After putting the period.
Uh,
Fee
uh,
for the period.
uh,
After calculating the period, which we have put it at.
Yes, after calculating the period already,
Done.
after calculating the period,
Already done.
taken, after calculating the period for which calculating the period, the point number 5 had run the market. That's all?
Specific settlement may be made in my favor. Otherwise,
Okay, what is, somewhere we write, no, within 1 week we said, in favor of the petition. Okay, and one more thing, you write, Miss R.B. Bora. Miss R.B. Bora, the learned counsel for the BTC submit that even if the writ petition was to be allowed, comma, the in terms of clause 11 of the NIT, comma, the market could not have been, the market cannot be settled with the petitioner as he was the third highest bidder. That's all. The writ petition is accordingly allowed. Is it common order? I don't know. No, no, only third. Only for third. The next, give me the date. Yeah,
even in this case, my lord, NIT lord,
you give this to her. The same thing, no, different, no?
This is
this is my lord, fast parking my lord,
passport,
same market my lord.
passport.
Now, my lord, here in this case, my lord, page 15 is the required document which are required to be submitted. My lord, page 1515.
No, no, what is the issue here?
Issue here,
Yeah.
issue here is that I have not submitted GST. Now,
Okay,
this is not
okay.
a mandatory requirement.
Okay, where is that?
My lord, kindly have a page 15, my lord. Serial number 8, my lord.
Yes.
Tender shall be attached with.
No, where does it say that your bid has been
Yes, my lord.
rejected?
Oh, my lord, page 1919, my. Is the comparative statement, my lord. The serial number 2, my lord.
Here he is second highest figure.
My lord, no
No
GST,
GST, no
Sell.
original sale.
no original clearance. No original clearance is not required, my lord. Now GST, my lord, kindly have it.
No original clearance certificate.
My lord,
Yes.
that is not required. have
I do not
submitted-
know. Why is it not required?
It is because Xerox copy I have submitted.
So where does it say that original is not required?
No, no, I have submitted, my lord. Now, only contention is GST clearance. Now, in this case, my lord, clause serial number 8,
Just a minute.
my lord,
No, you come to their affidavit.
my lord.
They have said that para 3, petitioner has not submitted required documents such as GST not signed, original tax clearance certificate.
Now, my concession I have submitted, my lord. Only part is that GST I have not submitted because as per NIT, it is mentioned as if applicable. And nowhere in the NIT it is stated, mentioned that it is required. That's why I have not submitted.
Why do you say that it's if applicable?
No, my lord,
Why should it be applicable?
Now, in the clause itself, my lord, GST is applicable,
Correct.
my lord, is
So
applicable.
why is it not applicable? Why is it not applicable?
Now, going by the NIT itself, my lord.
There has to be a reason why it says if applicable.
Right.
Now you are saying it is not applicable. Why is it not applicable?
So I made.
And what about that original tax clearance certificate?
As per my instruction, they have submitted, my lord.
They have said no, this is a question of fact.
My lord. I leave it up to your lord.
Yes. Yes, madam. Is original required?
Original or in tender document not say as original document.
Huh?
Normally what close
Data,
80.
we had done one case regarding
18.
GST necessary. GST certificate if necessary, comma, if necessary. That is the judgment. This, you see, this is required when you have a turnover of 20 lakhs or something like that. And some sales. It's only that,
Fine.
only in that ground. Then only GST is necessary under the act. Just find out. GST. Yes,
Tender
yes, madam, with regard to original.
18.
Clause 18 of the
Tender from page 16 of the writ petition. Original not stated, tax clearance certificate from block development officer concerned in case of house, public holding, public water tax, public electricity of rural areas, development block, and in case of residing town, certificate from the town office is to be submitted with tender form. Clearance certificate from
no
block.
side, no judgments in your favor.
Regarding GST, my lord.
No GST, so you don't have. I have got, but you don't
My
have.
lord, tax clearance, my lord.
Huh?
The India.
Original, with regard to
My lord,
original.
they have mentioned original. My lord, kindly have a look. 8, page 15 of
Yes,
serial number.
yes.
Tenders shall be attached to attach the following document from the bank draft, original land patta Jamagonti. And regarding, my lord, this GST land valuation certificate against mortgage property and land revenue clearance certificate. Only. Serial number, my lord, B, my lord, original was required. My lord, it is.
Yes, madam.
In the tax clearance certificate from block development officer. Not mention as original lot.
Not mentioned. Then why is it required?
But in every tender form, all are submitted original, except
They may submit, my lord, whether it is required as per NIT.
You see, the problem is in 8B, you said original.
I understood.
And you could have asked
It
for
would
the
be also
original. You could have always asked for the original if you had a doubt.
Others have submitted original lot.
Others have submitted original. I do not know where's the bar. But you do not have the GST.
Yeah, my lord, thing is that, my lord, this is not meant,
Huh?
not meant, it is applicable. Whether
Why?
My lord,
Why not applicable?
that it may be decided as per your lord.
We'll see next. You think about it. There is a judgment. There, I passed.
Patta original, not submitted. Land patta also is not submitted, I think, original. No, land patta also not submitted.
No, but that is not in your affidavit.
No, but in report, it is land patta also the good.
Land patta also not original.
And
And we'll go by their affidavit, man.
No, but we have to see also.
Lord,
Let us see the land patta. What is required? What is required is original land patta. Yes, let's see. So it's not there. Then goes. Your number 2 goes. Okay, right. Third, Mr. L.R. Laskar, J. Laskar, learned counsel for the petitioner. Also heard Ms. R.B. Bora, learned Senate counsel BTC. Then you take this order, order 25/8/23. Then para 2, huh? Then next, right. Ms. R.B. Bora submits that as per the affidavit filed by the respondent number 3, the bid of the petitioner has been rejected on the ground that the petitioner had not submitted the original tax clearance certificate from the concerned block development officer and the GST. Clearance certificate. She also submits that as per the original records which she has brought today, comma, the petitioner has not submitted the original. What? Original
Original, land. Close,
original land pata and Jama Bandi
yes,
copy.
close 8B.
She accordingly submits that there is no infirmity with the decision of the respondents in rejecting the bid of the petition. I have heard the learned counsel for the party. Clause 8
B.
bracket A,
B,
B, and no, B, comma, F and J
J.
of the NIT dated of the NIT dated 24/5/2023 states as follows. Page 15. As per 8B, clause 8B, the original land pata and Jama Bandi copy have to be furnished by the tender. A perusal of the official record which has been brought today shows that the original land pata and Jama Bandi copy has not been submitted by the petitioner along with his bid document. Then clause, as per clause F, 8F, comma, then dash, they put that, then you write, as per clause 8J, tax clearance certificate has to, from the video has to be annexed to the bid document. Though there is no specification made in the tender notice that the original documents would have to be furnished. The record show that all the other tenderers have furnished original tax clearance certificate. However, no, the above being said, the above being said, in view of the fact that the petitioner has not complied with clause 8B of the tender notice, requiring him to submit original land pata and Jama Bandi copy. This court is of the view that the the petitioner could not have been selected as the successful tenderer in pursuant to the tender notice dated 24/5/2020 as a mandatory condition had not been fulfilled by the petition. Consequently, the this court does not find any ground to interfere with the selection of the respondent number 5. The writ petition is accordingly dismissed. Next time.
13, my lord, service waiting. I have
13 and 14. 13, right?
no, my lord, 14.
13, what is the matter?
13 regarding fast parking.
What is the ground?
Market.
Huh?
Property flea market.
My lord, service. Your service awaited by.
Thirteen. Correct, 13. Number 3, who's number 3? Actually?
Respondent number 3, secretary.
You are supposed to file affidavit.
I
No.
No, I file.
Service. Of service. Have you taken steps? That's
My
the
lord,
service.
not
Okay, Mr. J. Laska. Please for how much time?
1
A week's time. To file affidavit showing service of notice by way of justice service upon the respondent number 5. This is the matter after a week. Same.
14, my lord, same official. 11. 4, 5.
Huh?
18, no,
Deemed to be complete.
completed, sir. They are also same down by PSP. Original text, yes, sir.
Only original or same again that original not given?
Original,
Original text.
original and patta here also not given by.
PSP.
Same with.
Original not given again. Original land.
Then patta. Same as 11.
Then it goes, but tax clearance certificate. There is under the act. Unless you have got, I think, turnover of 20 lakhs or something like that per year. Then GST is required. If below 20 lakh, I think GST is not required.
Let it be posted after 1.
No, but that is only one aspect.
Land
No, that again you will fall in that original land pata. Because the tender notice requires you to submit original land pata.
Yes.
Now check the record, just see if it's there. If it's there,
No,
good enough for you. If it's not there, then it goes. Why keep it pending?
Kerua market, Kerua market, I just thought. No, it's not that.
Let her check. Let it check. Okay. Okay, out here in that you take the order dated 21/8/23. Para 2. Okay. Para. Others will all remain the same. The item 11, huh?
obliged.
You put it in item 11, okay. That's one. 16. 15 or 16? This is 16.
The matter is relating to Cancer Institute. The selection process is complete. Now, the attendant, these are very important posts. Unless they are appointed, the operation, diagnosis, all these things get delayed. And a lot is aware. So for the cancer patients is concerned, there are 4 stages. Number 1, number 2, number 3, number 4. Up to 2, somehow it's recoverable. When the patient reaches to 3 and 4, it's very dangerous. Now here, because of the stay order, quite unnecessary, I will substantiate your lordship. Now, these selection already completed, we are not in a position to appoint them. As a result,
We're not in a position to appoint them.
We are not in a position to, your lordship, can we see the order passed? Order dated 13/1,
13/12.
13/12/2023. In what context this order was passed? The petitioner projected before your lordship that these people, there is a status quo order given by the tribunal. Now, status quo order in what context, and whether the status quo order is remains. So the status quo order was passed, they projected before the tribunal that their services will be over unless some protection is given. And this position is not correct at all, they are still working. Now, the reference was made that since they are daily wages workers, certain limitation will have to be maintained to giving their wages. That reference your lordship will find in page, Lord, I'll just take your lordship to that.
Anyway, what is his, what does he want to say? Let us, what do you want to say?
My lord, regarding the appointment, we have to raise the industrial dispute before the deputy labor commissioner, central government, Guwahati. And in during pendency of the dispute, before the labor commissioner, they have retained two of the employee petitioners, number 1, 2, and 2. Thereafter, the constitution failed. After failure of the constitution, the labor commissioner referred the dispute to the central government, which accordingly referred the dispute to the central government industrial tribunal from labor court for disposal, having some issues in the form of dispute. During the pendency of this reference before the central government industrial tribunal, the respondent made an advertisement for filling up the post of filling up some post of along with the post of the ward boys and ward girls who are working, that is the petition, who are working since last 5 years to 17 years. From the very date of inscription of the Guru Cancer Research Institute, the petitioners have been, some of the petitioners have been working since last 17 years.
Last
17 years.
17.
And some of them since last 5 years. My lord, they are doing the same nature of work as ward boys and ward girls, which is equivalent to the post of trade helper. Trade helper for which post the respondent has advertised for filling up, ousting the petitioner. My lord, the petitioners, they have been employed in different departments, different nature of work, such as wards, as ward boy and ward girl, laboratory assistant, chemotherapy assistant, in all spheres of activities they are working since last 15, 16 years. And now, just after taking up this Vigorua Research Cancer Institute under the central government administrative control, they have made this advertisement. We requested them for considering our case, giving some relaxation and condoning our educational qualification, etc. But they did not agree. They did never made any provision for accommodating us in the latest advertisement. Ultimately, during pendency of the reference, again they by arbitrarily ousted the present petitioners, that is 13 number of petitioners. Two of the petitioners
Ousted, who ousted?
the management, my lord, using force, using their security personnel. They ousted the petitioner number 13 to 15. Yes, 3 to 15 minutes. So they, if you approach the central government industrial tribunal labor court for their redressal due to violation of their status quo order, etc. Accordingly, the central government industrial tribunal labor court Write their order dated 14 to let us go 2/7/2021. But during dependency of the referent, the respondent had started process of recruitment, etc.
Started the process of?
Recruitment to the
Okay.
post against which the petitioners are working. And moreover, it may also be mentioned that originally there were 30 numbers of workmen. 30. And during pendency,
30.
30. During pendency of the dispute before the labor commissioner, at the instance of the management as well as pressure upon them, 15 numbers of the disputed the workers, they have joined through some outsourcing agency.
They have joined where?
In same institution.
Through some
Now they-
outsource, through some outsourcing. So they've got no contract with the with the hospital.
Management directly.
uh,
So they with the management directly.
they don't have any contract with the management.
These 15 numbers.
They've got it through their employer.
Yes.
Separate.
Those persons are working, my lord. Now it has become very much urgent and important that their work is being installed. Same persons are working.
Their work be stalled.
My marriage consent has already been submitted. There will be urgent and a serious nature of work. The same nature of work is being done by the present petitioner.
Is there some recruitment rule?
Recruitment rules, my lord, there was no recruitment rule. Initially, the Guru Cancer Research Institute was,
Okay, petitioner number 1 was appointed when?
they were appointed on some personal sources on their appearance.
Huh?
On personal sources on appearance.
Personal sources?
Yes, there was no direct interview, direct advertisement. So far,
I'm asking you, when were they appointed? Date?
my lord, page number 13 of my petition, I can read. Page number 13 of it.
35.
30.
13.
13. Moinul Haq, Idil 1, Moinul Haq, 4/10/2007. Honi Dekha, 2/2/2008. Navajit Sharma, 1/11/2011. Tul Dekha, 6/4/2009. Samim Kumar Nath, 15/9/2009. Deepak Nath, 15/10/2009. Amal Dekha, 11/11/2011. Ratul Kolita, 25/8/2016.
Okay, we'll take up after lunch.
Hello. The petitioner were appointed without holding an interview, without holding any due procedure of the police. But they were,
Louder.
they were appointed, engaged through some personal sources.
Huh?
Personal sources. Some people told them they appeared. Appeared and after by holding interview, they have been appointed as per by itself. There was no due process of appointment by the management. And since then, they are working till date. Except two petitioners, that is petition number 1 and 2.
How many posts are to be filled up?
Total 30 posts is there. 15 were taken from outsourcing.
Let us see the advertisement.
Pardon?
Where is the advertisement?
That's it. Page 28. Post of attendant, you'll will find 12 posts for BBCI.
Where you attendant, yes.
Attendant, you'll will
12 posts in BPCI got it, yes.
Yes, we are concerned with the 12 for attendant and 27 you'll will find that is not for BBCI, that is for TMH Mumbai.
That's from Mumbai.
We are not concerned about that.
So yeah, now you want to fill up these 12 posts.
Yes.
Of attendant.
Right.
Now, what their grievance is that they'll be ousted from their jobs.
You know, the lordship can see the prayer question, what they want it is.
Okay.
You lordship will find that at page 24.
Yes.
By direction should not be issued to first modify the impure advertisement number 2022 published in the Assam paper, the daily dated 2022. In respect of the post of attendant and paid helper, they are committing mistake there.
No.
It's for the post of attendant only,
Yes.
not for the post of paid helper, as you not in the advertisement. And then at page 25, and to allow the petitioners to participate in the recruitment process for the post of attendant and paid helper by relaxing the age. Now, who stopped them to
Apply.
apply? They did not. Only one person applied, and when she was called for the written test, she did not appear. So none of them, except the one person who participated, and after that he did not appear. Now, how they can file a writ petition for a recruitment process on a regular basis to be held? Now, the selection process is all over. We are not in a position to appoint them because of the stay order granted by this honorable court. And my lord, you lord should kindly see how the order reflects.
No, no,
Lordship can-
just a minute. Page 28 is the page.
My lord, status quo is granted by the.
Just a minute, just a minute.
So for BBC, my lord, we are not concerned with the trade helper, only attend. Trade helper is for Mumbai,
Yes, I,
Tata Memorial.
yes.
Now, your lordship can see what government they have made in the writ petition. Your lordship may kindly turn to page 11, paragraph 6.
Yes.
That the dispute started when the HR and administration cum coordinator of the office of the respondent number 3, Guwahati, published an advertisement by number so and so, rated so and so, recruit paid helper similar to the post of ward boy and ward girl. Now they are saying they are ward boy and ward girl. Now for paid helper, there is no advertisement. That is in relating to TMH in Mumbai. So therefore, their case is not for the attendant. And your lordship can say another thing. These persons, your lordship will find something in the writ petition what they have pleaded. And
So their case is with regard to trade helper,
paid helper.
not with regard to attendant.
No. In regard to attendant, my lord, it is not their thing. There is no recruitment for the paid helper is concerned. So far, BDCI. My lord, in the advertisement, it's page 12, right? Serial 2. Paid helper posts are there. It's 23 posts. Mumbai. That is Mumbai. Not for BDCI.
You see at page 28, page 28, please look where the trade helper is for, it's at 2, serial number 2, correct?
Yes.
It is for TMH Mumbai, the next line.
It's Tata Memorial Hospital, Mumbai.
It is not for PBCI.
Number one, my lord,
Number 1 is for attendant,
attended.
correct?
So we are already working as ward boy and ward girls.
Correct.
That is, we
But
are
then
doing-
you have not, your case is not with regard to attendant. Your case is with regard to trade helper.
My lord, we have given this option.
Huh?
Whether radial per is so equivalent to that. And they are already working as attendant. Ward boys and ward girls, they are doing. My lord, he is a confusion in the phraseology. My lord, attendant has different connotation. Paid helper has different connotation. So he should not confuse.
Let us see the appointment of the petitioners, appointment orders of the petitioner.
It's not enclosed, my lord.
Not
My lord, actually, they are fighting for their engagement. And they are going to be ousted. Replacing them, the new appointment is going to be. My lord, I can, with all humility, I can say that my learned friend is saying that they will be ousted. Now, the same sort of argument they made earlier also before the tribunal. Now, in the petition, your lordship will surprised to see what they have stated. They have stated that they will be terminated from this and this date. Therefore, the status quo order is required. Now, these, my lord, the statement is totally misleading and incorrect in the sense. My lord, they were never ousted. They are still working. Your lordship, I'll
No,
take
but
your
what
lordship-
they are scared of is once these attendants come into the picture.
Not at all, my lord.
So what we can say then is let the selection process continue.
It's over, man.
It's over, but then selection appointment has to be issued.
Yes.
So once after the appointment is all issued, then if any step is taken for you to oust them from their service for whatever reason, prior 1 month's notice should be given.
My lord, I can assure your lordship. My lord, a status quo order is pending before you are
Mr. Counsel, pending, so what?
in the tribunal. my lord.
So
My lord, tribunal.
if it's pending before the tribunal, why have you come here?
Tribunal, the presiding officer is absent, my lord.
So, but then the order is still,
Finding, my lord.
Huh?
Finding no other order.
huh? Mr. Counsel, let's be very clear. If there is a status quo order in the tribunal,
Yes.
which prevents them from changing your position of your appointment, okay, then what is the need for you to come to this court? You are already protected by the tribunal.
My lord,
Why have you come again here?
tribunal is absent, my lord, no presiding officer is
So what?
present.
So then they have, if they want, then but the order is still binding. Just because the tribunal is not present, doesn't mean that the order has become a nullity. It's still a valid order.
My lord, they are taking steps to violating the order status quo for appointing the new recruit by their.
Let us see the tribunal order.
Actually, it's not correct, my lord. This honorable can be lost. Can you see the order dated 5/1/2024?
5-1.
2024. My lord, page 88,
Just a minute. 5-1.
2024.
Yes.
The so-and-so submitted that the projection made in the read petition is not correct. And though in reference case, there was an order of status quo that will not give any right to the petitioner. He further submits that apart from the fact that the Industrial Dispute Act 1947 provides for paying for interim relief in the form of section 33A, the petitioner did not even apply under the present discussion process. By referring to the order sheet, it is submitted that rules are incomplete and therefore confusion has arisen leading to passing of the interim order. He further submits that the recruitment process is complete and because of the interim order, appointments are not being able to be given, whereby public interest is being adversely affected. Now, the last line is important, Melu. The matter can be resolved by production of the certified copies of the ordered class by the learned CJIT Guwahati in the connected reference fee. Now, I'll produce my notice, Sona will put such an order to furnish the certified copy of the order. Fee. Melody, I will take your lordship to those order sheet, and your lordship will find the status quo order was never continued after 16/11/2001. Because of the reason
2000?
16/11/2021. After that, that order was discontinued. First order, your lordship will find 27/2021. Your lordship may go to page 2. Having heard, your lordship may see from there. Having heard the learned counsel appearing for the workmen, and also having gone through the petition and other materials available on record, it is ordered that the concerned management shall maintain the status quo in respect of the employment of the concerned workmen of this reference date till the next date of the date till 13/7/2021. Now, your lordship kindly come to
37.
13/7. 13/7, yes. Even on 13/7, if your lordship see page 3, the last para, in view of the order passed on so and so in respect of the condition of service of the concerned employee will continue. And it continued. Even on the next day, 31/8/2021, it is continued. The lordship may skip, and the lordship may come to page 5, order dated 2/11/2021. In view of the order passed on so and so, in respect of condition of service, the employee shall continue. Then order dated 16/11, which is the order. After that, it is not continue. Learned counsel for the management side, Mr. So and so is present, and the workman.
But it says shall continue.
Yeah.
But there is no, it does not say till a certain date. It says shall continue on.
Yeah.
It does not say till the next date.
My lord, continue, fix 16/11/21.
Maybe,
For
maybe.
submission of.
But then it says shall continue. It doesn't give a date.
No, your lordship kindly see 9/12.
Hmm?
9/12, order dated 9/12, 8:30.
And
9/12, page 10. Page 10, your lordship.
yes, to complete it.
There is a, my lord, page 13. Correct, yes, 13, my lord, your lordship. Letter, your lordship will find 9/12/2022. Mr. So and so learned advocate for the workmen and Mr. So and so learned advocate for the respondent at present. During pendency of the reference case, the concerned workman filed a separate application dated so and so under section 33K of the IGA, contending therein that during pendency of the reference case number 2 of 2021, applicant number 1 and 2 were arbitrarily terminated from service without any valid ground, and 13 other workmen are still working. On 2/7/2021, when the workmen were ousted from their working place, they preferred an application before this tribunal to bring the illegality of the respondent to the notice of the tribunal. On the basis of the same,
They were ousted. They were not-
1 and 2, my lord, they were ousted on 9/9/2019. Now, your lordship will find during the pendency of the application, this position is not correct. Because before the pendency of the application, before the reference case, they were out. I mean, by your order. Now, then 13 others workmen are still working. On 2/7/2021, when the workmen were ousted from their working place. So this is also not correct. I will 9/12/2022. Ousted from the working place, they preferred an application before this tribunal to bring the illegality of the respondent to the notice of the tribunal. On the basis of the same, a status quo order has been passed. Thereafter, on 16/11/2021, the court observed that non-filing of a separate application was a matter of technicality only,
In their application, the petitioner have prayed for directing the respondent to reinstate the terminated workman. The application is moved by learned advocate for the workman. It appears to me that the case disclosed in the application is different from that which is formulated in the reference case. The application file praying for reinstatement of the two workmen in the present complaint case under section 33A of the ID Act cannot be considered simultaneously with the reference case, as they would lead to separate awards depending upon their subject matter. The terms of reference cannot be enlarged on the basis of subsequent application, which themselves are separate industrial disputes. In my considered view, this application file in the reference case is responsive. The petitioners are therefore granted leave to initiate an independent proceeding under section 33A of the ID Act in respect of the relief they have prayed for in their application dated so and so. The petition be registered as LCP separately, issue notice to the party, directing them to file their written statement at least the documents and effect. Now, that is. Now, my lord, please, page 6. My lord, once again, I'll take your lordship, page 6. Page 6, your lordship will find para, my lord, G. Last but one. It is further directed that the order passed on 2/7/2021 shall remain in force until the next date. Now, until the next date means 17/12/2021. And 2/7 for the 2021 was the status quo. Then 17/12, your lordship may be the next date, 27/7/2022.
I know, so this is wrong, I think typographical mistake.
Yes. But then, my lord, now supposing, my lord, status quo order as such not there, even if it is there, even that the consequence will be what?
Huh?
Consequence will be what? They are working as daily wage level. We are not disturbing them. The reference case is pending. The reference case will, court will adjudicate the matter. So now, those of that status quo order, does it mean these persons who are daily wages workers
The status quo pertains to their service.
for
That's
their
right.
service, my lord? Now, whether that particular order will come into play here, that when there is an advertisement, because of that status quo order, automatically these will also.
No, but can you give an undertaking that the post that is going to be filled up, that means that attendance post.
Yes.
Is not the petitioner's post.
Right. It's not the petitioner, okay?
Can you give us that undertaking?
Yes, yes.
Once you give us that, the post held by the petitioners and the post advertised, that post of attendance advertised, uh, is different.
Yes.
Then the status quo out here can be lifted.
Well, it is their own case, but they have stated in.
No, you are leaving, I am leaving that aside.
I know.
Because it appears also there,
Yes, yes, but I think
if you can give some undertaking, yes.
I know. Yes, I will do it. Since 17/12/2021, the presiding post of presiding officer will be become vacant.
Huh?
Post of officer, presiding officer will become vacant. On completion of this term, the tender over the chart. Thereafter, some link to Mr. A.
Huh?
Thereafter, some link order dated 27/7/2022 value. 27/7. Yes. Yes, yes, yes. These are different matter in the subject of section 33A. Pilot order dated 27/7/2022. One
Dr. Suryendra Kumar Thakur has been posted as link officer.
So. My lord, link officer means presiding officer.
Correct. Link officer means presiding, you see. Do you understand the meaning of a link officer, Mr. Counsel?
Yes, my lord.
What does it mean?
But he is not
What does it mean?
operative order, my lord, the order mechanism.
Yes, but
Simply SD region, or
Huh?
that.
it will be said SD. SD means assigned. You see, link officer is there everywhere.
But officer, not present. Just,
Mr. Counsel, we have got to go by what's written here. Link, you do you know the meaning of a link officer? Do you know the meaning?
my lord,
Please look when I'm asking a question. What do you understand by the word link officer?
just to work as a link officer, just temporary assign, in charge officer.
Till
As in charge,
till that person is not there, somebody will take his place. As it does not mean that he will. It's temporary, no doubt, but he'll have all the powers of that officer.
moreover, my lord, at page 97,
No,
vacancy, page 97, my lord, please kindly.
anyway, you see, there are two things. One is that he's having a problem that he might be ousted. So that's why he has gone there to the tribunal. Now, before this court, he made a challenge to the advertisement. What is wrong?
My lord,
Only thing, of course, with the wrong
What is the-
understanding of facts. Maybe.
without participating there,
How can he
can you
challenge?
challenge it? And it is for the recruitment process is for employment of the regular employee.
Regular
Daily
of
wages
attendant.
worker who did not
What are
participate.
you? Where is your appointment order?
No,
My lord, no appointment letter,
No appointment order.
but since then they are working continuously. They have issued certificates also, my lord, kindly.
Is there any rule for appointment of attendant? Any rule?
no, that
Any
we shall-
bylaws?
that we shall have to see. But here is a case, my lord, it is not for the education of these persons here. My lord, they haven't challenged it.
My
They have
lord,
come up for advertisement, challenging the advertisement.
my lord, page 38, 38 to page 52. May kindly be explained. These are the certificates issued by them. This is to certify that renewal of son of Nisar Ali, village
My
such
lord,
and
to cut
such
out the matter,
and so has been
the
engaged.
reference is pending to the
Engaged.
tribunal. The tribunal is
Please,
looking to all that. If you are to get it, you will get there at best from the tribunal what they can get. Daily wages services to get back. This much only, not beyond that. Now, this is the matter.
In the tribunal, they have not challenged the advertisement.
No, nothing of that.
My lord,
And now,
it is clearly mentioned in their certificate. On daily
Advertisement of
basis,
30/10/23.
since
Mr. Counsel, please do not interrupt. Please wait. When I have a problem, I'll ask you. We have heard you for a lot of time prior to lunch. Okay. I'm trying to understand the case. Please wait.
the lordship look at paragraph 2 of the writ petition.
No, but one problem they have is that their jobs will be affected by this appointment.
No, not at all, my lord. These are the employment of regular employees. They could have participated, my lord. They did not.
But that is a different issue. They could have participated.
The recruitment process was for the regular employee. And-
what are the posts that they are holding? They are appointed as what?
What boys and girls?
What boys and girls?
Daily basis,
How many what boys and girls do you have both in the hospital?
that we shall have to.
Because you see, one thing they've been working for 5 to 17 years. That means they've been able to do their job.
So I can assure you,
Now-
see, so long the reference proceeding is continuing, well, adjudication will be made.
No,
They are not
maybe,
going
but
to-
maybe, but once the posts are filled up.
Yes.
As per the advertisement, then it may be that their jobs are on the line then. So we'll have to see how many, you just give me. You make a affidavit saying how many posts of attendance you have in this BBCI. How many posts of what boys and girls you have in this BBCI. How many are filled up? And by whom?
You know, today the position may be something. After
You-
few days, it may increase also.
Maybe, but then you give me black and white, what is there?
That can be given.
Then once
Then your lordship
they're
may do-
protected for the time being, then we can do that.
Your lordship can do one thing, subject to the outcome of this case. The appointment may be given, otherwise, my lord.
No,
nothing
no,
will do, summary,
no,
cancel
no,
my
no,
summary.
no. No, then the problem can arise. The problem can arise. If you first give me the position, the strength, the sanction strength of what boys, what girls and attendant. How many persons are actually holding the post of what boys and girls? And the names of those persons and including attendance. Then we'll decide. Right. Heard, Mr.
Only one thing, my lord.
LCD.
Your lordship kindly consider one thing. We are not considering the case of what was done. Advertisement is for attendance.
I know. I'm not on that. Once you can show that by in the affidavit, once it is shown that there are ward boys and posts, sanctioned posts, and there are sanctioned posts of attendance. And if that affidavit clearly shows that they are separate posts, then the case goes. Then they're protected. My lord, they are doing. Mr. Khan, that's enough. Heard Mr. LCD, learned counsel for the petition. Also heard Mr. That learned senior counsel for the respondent.
Yes.
For the respondent. Yes, sir. The respondents shall submit an affidavit stating the number of sanctions posts of what boys and what girls and the number of posts that have been filled up on regular basis and on daily wage basis. The affidavit shall also state the number of sanctioned posts of attendance and the number of posts that have been filled up on regular and daily wage basis. The affidavit should be filed within a week. This is a matter of 2 weeks. Huh?
My lord, where in a hurry, my lord, because your lordship can understand that.
No, you give me the affidavit tomorrow, we'll file it on Friday.
All right.
It depends upon you, how fast you are saying a week, that's the thing. So we do not, when can you submit an affidavit? Or we can list it on Tuesday, whenever, we list it on Tuesday.
Your lordship may fix it on Friday. We shall try to file it.
Okay. Huh? What's that? It's small issue.
My lord,
What?
after 20th.
Why? Yeah, in a hurry. No. This is you see, once the affidavit comes, depending upon what they say in the affidavit, you might be protected.
My lord,
I'm asking this affidavit only to safeguard your interests, not any other. You're not trying to understand. You're not understanding or you don't understand, I don't know. But it is for your interest that I'm asking this question. This is a matter of night.
One thing, my lord, I just want to clarify. So far, sanction post, my lord, the post of attendant and this what was that can be given. But the daily wages, there is no such.
I know. What I'm saying is, what I want is actually, those posts of attendance, regular posts will be there'll be regular. You might be having persons working as attendants on daily wage basis. It's only on that. I'll clarify that.
Fine.
Even for that ward boys and girls.
Yeah.
Maybe sanctioned regular posts are there and regular appointments to those posts might be. But these persons are on daily wage basis.
Yeah.
So I want to know how many are vacant. The regular sanctioned posts.
Posted there, whether these are all filled up. or
I-
they are
um,
lacking.
Yes, yes. So that it is, we can, whether I want to see whether their interests are protected.
Yes. But my lord, till now, I can tell you, lordship, in the reference case, he will be proceeding on. There is no such. problem.
Maybe, but but he was protected now.
They sometimes they wanted to say we have ousted them. That was totally, my lord, incorrect statement.
No, but what they're trying to say is that in the future they will be ousted because of this. So that is why I want this this affidavit now, so that in the future also they can say this issue now with the advertisement is a completely different issue, and this is this affidavit shows that what boys and girls are there, they are vacant posts to which they can be accommodated. Only on that.
At the same time, my lord, I just tell them, they should help themselves. So, the lordship will find the list of petitioners.
Unfortunately, they didn't do it. They have not done it. What we do.
Advertisement for all.
No relaxation.
Relaxation 5 years given. The advertisement says the relaxation of 5 years.
Plus 17, 18 years. And their nature of work is continuous. And continuous.
Maybe, Mr. Council, we won't go into those issues.
They are doing.
We won't go into
Also
those
can
issues
be
now.
that some of
Can
the petition I have seen, is it about 26?
Ah.
5 years relaxation is there, they can very well could have applied, they did not. For what reason, I don't know. Now the reference case is pending. Can we may not terminate their service? It's impossible. That's why I'm assuring your lordship that service is.
No, just give me the
Yes, yes,
that advertisement, the affidavit. Once that affidavit is there,
But-
then they won't have anything to fear.
So your lordship is fixing on
Friday.
Status quo in respect of the condition of the work of the work.
Next.
Friday.
But in this case, respondent counsel, Mr. L.P. Sharma,
Mr.
he expired.
Oh, Respondents Council expired.
L.P. Sharma, I don't know if there are number of lawyers are here. I have not seen it.
So what to do? Let us see, there are Mr. J.K. Goswami for one. Then, Mr. What did you say? L.P. Sharma.
He's the senior partner. He's my friend, so I know he fixed it. Expired.
L.P. Sharma.
L.P. Sharma expired.
Okay. When?
About 6 months back, 6 or 10 months.
So the tall council. no? Tall.
Yes, sir.
Huh? Now what to do?
Let us fix a date day after tomorrow. Let us see the date for approval. In the meantime,
For hearing?
hearing matter.
Or I think no more. Thursday we said no more because we have got too many fixed. Only we can fix it, but it's only to ensure that there is someone on the other side. Not for hearing, it will not come up. Huh? Huh?
In somebody's excellence, I don't want to argue. I will try to connect any of those thoughts. But
We will list it next Tuesday. Next Tuesday. Is it okay? Day after tomorrow, though,
all the
we won't have time.
Lordship can keep the date any day.
Give a date after that. After that. Right. Is it okay?
Tuesday.
28? Mr. A. Dasgupta appears for the petitioner. No one appears for the respondent. Respondents. It is submitted at the bar that the counsel for the respondents, Mr. L.P. Sharma, had expired a few months back. L.P. Sharma expired a few months back. Yeah, what to do? However, all this indicates that there are other counsels for the respondent, for the response. In the interest of justice wisdom, list this matter on 20th.
I pray for some time in this matter. I have received some instructions.
What instruction?
Lord, this is a matter with regard to dismissal from service.
Ah.
That, my lord, there is an order from the labor commissioner, my lord. And my lord, there is a condition with regard to vacation of the quarter, my lord.
So?
Don't know thereafter what happened, my lord. And my lord,
Oh.
the report of the domestic inquiry is also.
Yes. What is the case?
Lordship, the issue relating to hackathon of the quarter.
Ah.
Actually, my husband was previously working as a driver in the Moorpuloni tea estate.
Hindi?
Moorpuloni tea estate, Lord. Tea garden.
Ah.
And after his retirement, because no notice has been issued to him to vacate the quarter. In the same quarter, Lordship, in the same quarter, I have been occupied as a labor quarter, not a staff quarter. From labor to from 1969, Lord.
So
After my retirement, the no notice served to him to vacate the quarter because I was also daily rated worker in the same garden. Petitioner is daily rated worker. Because notice was served to me.
how old are you now?
Now 62, Lord.
62.
Though it is written in the affidavit as a 65, it's a typographical mistake.
My lord, as per affidavit in the 2015, she was 65
It
years.
was not
old.
65.
Perhaps 75.
No.
As per, so
Affidavit
you are 65 years old.
in 2014, man.
It should be 52, Lord.
Mr. Counsel, I cannot change the date of
But
affidavit.
in the award also there is a two part. Lord.
That is a different thing. Now,
Now-
tell me one thing. Your husband retired as driver when?
Driver in 2004, Lord.
2004.
Four.
Driver from the
Moorpuloni tea estate.
tea estate.
And I was also working as a laborer, Lord.
You're working as a laborer.
Laborer.
And then, so now you're 65.
65, I am now staying with my son. She is also a driver.
What is the age of retirement?
60 years, Lord.
60 years.
Sometimes
So even if you are 62, you are still over.
there is two parties there. One is in the order of the Assistant Labor Commissioner. Direction has been given to vacate the quarter as well as to reinstate me, Lord. That part was not by.
Now reinstatement is
Now it is not possible,
not possible.
but they have not reinstated me, Lord. That is also, they have violated the order, Lord. And they have not executed the order. Lord.
Anyway, reinstatement for which period?
Reinstatement from, it is reinstated by the award dated 2/4/2013, Lord. 2/4/2013. Page 13/9, Lordship, last part.
So are you still in the quarter?
So Lordship, now I am staying with my son. Son is also a staff, Lordship, residing in the same.
Now you go out. You cannot take advantage of this. You go out.
Because I was not occupying the quota. Quota is occupied by my husband.
Correct.
So-
And your
so
husband
no
retired in
notice was served to the
2004.
husband, Lord.
Huh?
No notice was served to the husband.
So what?
Because I'm the,
Oh.
as a wife, I was staying with my husband.
Yes, now
That
you
is-
go.
this is
Now
I
you,
have stated in
now
my-
you go. He retired in 2004. 20 years you have been there.
Now my son as a staff,
Maybe
residing in the
this
same
is not this is not hereditary.
no, I,
This is not hereditary. Then
But we-
afterwards, their son will also occupy.
but their reinstatement part, they have violated the order, Lord.
Then for that, is there any remedy? What is the remedy if they do not?
Maybe
Uh,
at least till my retirement, that is back wages could be given to me at least.
Now, if they do not comply with the labor commissioner's
Order.
award, what is the way to execute an award?
What is the filing criminal case, Lord?
Huh?
This time is barred, Lord. Filing a criminal case in the CGM.
What is the procedure?
It will be filed by the inspector, not by me, Lord. Labor inspector.
If any award is not executed, they can file application before the labor commissioner to execute the award.
Under which provision?
Fix that, but
Let's see.
But my lord, this order is a conditional order, my lord. It says, my lord, first she has to vacate the quarter,
Okay.
then there is reinstatement.
Oh, she has to first get the
Well,
quarter.
lord,
Okay.
kindly see page 39, my lord.
39.
My lord, second paragraph, my lord. Page 39, my lord.
39. Okay.
39.
Yes.
Second paragraph, therefore, may I read?
Yes.
Therefore, under the circumstances, I have held that principles of natural justice is followed by the management in their domestic inquiry fully, so I have decided this issue against the workmen. However, in respect of issue referred by the government of Assam, it is found that though the management is justified dismissing her from service and also on that point, she would not get the
No, she would not get reinstatement.
then, my lord, then, however, due to the good gesture of the management, I feel that it would be worthwhile to pass order in favor of Billo Bejgiri, well, she is the petitioner, with the direction that it is directed to her to vacate the quarter forthwith within 10 days, and thereafter it is directed to the management to reinstate her. It is found that as Billo Bejgiri is not in service, so I feel that it would not be proper to pass an order for back vacation.
Okay.
And my lord, then my lord, come to next page, page 40, my lord, what she has given a letter to the assistant level commissioner as she is approaching this honorable court, so not to execute this award, my lord. So this is written by the petitioner to the assistant level commissioner.
And this is his writ petition,
Yes, my lord.
her writ petition.
Yes, my lord. So she is not
Don't say-
getting the quarter and she is blaming me. But
Ah.
this is a conditional order and this is the management has said.
Okay, you kick her out tomorrow. Where?
Put the matter appropriate order may be possible, because I'm earning only 110 rupees at that time, my daily wages. Or I am,
Now you're earning enough.
no, not earning, because I am totally now old age, Lord, and depending on my son. He's also driver residing.
Please leave the quarter immediately.
At least that is the provident fund, maybe I may get the provident fund also. This is a separate issue. They're allowed to withdraw the provident fund, other commodities, they have to. My provident fund is deposited there.
You don't have you don't have any right to claim anything. You have to leave your quarter first.
And leave, I will leave, Lord. But one is that till the date of
Till you are reinstated, you have got no right to claim anything.
no, till the dismissal, at least my deposit I can get.
I don't know. That is not the issue here.
Oh.
That is not the issue here. And this writ petition is filed and he's asking not to execute the award. That means she's happy with the award.
He's not happy with
She's
the-
happy with the award and not happy with the award also. Both.
Both.
She wants the award to be as it is,
I think.
without being implemented,
The only question.
and not asking for setting it aside also.
This part is relating to vacation of the quarter lot, vacating the quarter. That part-
But your reinstatement is subject to your vacation of the quarter. Anyway, you have saved enough money while being in the quarter. More than what you would have earned.
No, because they have to get the instruction. Because my son is also ambulance driver. I do not know. My commission is before he lost it.
So
Maybe-
your son might get the quarter, that's a different issue. But you cannot stay.
Because son is living there. My husband was working as a
Okay, now your son is there, you have left.
I was not occupying. My husband was occupying. Now, why they have not intimated the notice to the husband? No? Because as a wife, as a right, I was staying with my husband. I am ready to vacate because what is about my husband? He is now 75 years old. So why they have issued notice to me directly, I do not understand. Because I was not a staff, because my husband was a staff member. He was occupying the quarter. After retirement, notice should be gone to him. No, in Jakarta, after retirement, you don't have a liberty to stay here. As a wife, they have issued notice to me. My son is also, that is, staying there. No notice was sent to my son. So I do not understand that is the stand of the management.
Page 16 is the matter domestic inquiry report, paragraph 1 which here it is.
Domestic and pay, it is reflected, husband was occupying.
So she was illegally
Just
occupying.
a minute, just a minute, just a minute.
Page 16 also.
Just a minute. Why did they try, why did they try to evict you and not your husband? Your
I
husband
do
died
not
or
understand
something?
why they,
But the husband was not there. He was just
Oh,
there.
your husband was not living there.
2004 retired.
no,
And left.
he is living there.
At
He is-
one point
Huh?
in time he was.
Entire
there, but
family is
then
living in that
he left
quarter.
out.
Huh?
As per my instruction, my lord, the husband was, and after 2004, he was not living in that quarter. The petitioner
Okay,
was
okay,
living-
petitioner.
Yes.
So petitioner, the husband left the petitioner also.
Yes, and that-
And the
that's-
quarter.
And that's why it is said in the domestic inquiry report that he was illegally occupying that staff quarter. Although he is a labor in the garden.
no affidavit has been filed in,
Must be a very strong-willed woman.
no, Lord, this. In response to.
Husband also got scared and ran away.
No, I am also interested to vacate because in my old age, but I do not understand
But
why.
you lived there for after 20 years of unauthorized occupation, high
No,
time you leave the place.
I do not, as a laborer, I do not have any option. Where my son
Just a
will go,
minute,
I-
how about the management? How much is it there? Hmm. Okay, okay.
Lordship must in the appropriate order, before closing my, that is the submission, Lordship, the company which my petitioner is working was a central government company. Because reference has to be made to the CGIT. law. At that point
Mr.
of time,
Council,
reference-
now you're retired,
No,
you're
yes,
60 plus.
but
End
at
of
that
the
point of
matter.
time, reference was good.
Right.
Bad Lord.
Heard, Mr.
He does.
Learned Counsel for the petitioner. Also heard, Mr.
A.K. Gupta for respondent number 5.
Right. This petition has been filed by the petitioner against the award dated 2/4/2030 passed by the Labour Court Dibrugarh. In reference case number 4 of 2010, by which the learned Labour Court came to a finding that the management had followed the principles of natural justice, had not violated the principles of natural justice in taking a decision to direct the petitioner to vacate the quarter he was occupying in the Murpur Loni estate. The learned tribunal also came to a finding that the management was justified in dismissing the petitioner from service. However, as the learned Labour Court found that the management was ready to return the job was ready to reinstate the petitioner into service, subject to vacating the quarter by the petitioner. The petitioner was directed to vacate the quarter within 10 days, and the management was to reinstate her thereafter. The brief, it's correct. The brief facts of the case is that the petitioner's husband was employed as a driver in the Murpulani tea estate and had been allotted a quarter in which he had been staying with the petitioner, bracket wife, with his wife, bracket petitioner wife. The petitioner's husband retired on 1/10/2004. So while the management tried to vacate the petitioner from the staff quarter and allot her a quarter fit for a . You're a laborer.
Labor,
for-
daily written labor.
Fit for a laborer, comma. The petitioner refused to occupy the workman quarter allotted to her. No, refused to occupy the workman quarter allotted to her and continued to stay in the quarter allotted to her husband. The management thereafter started departmental proceedings against her for defying the management in vacating the quarter that had been allotted to her husband. The petitioner being dismissed from service on having been found guilty of the charge of not obeying the decision of the management, comma. The matter was referred for settlement to the Labor Department. As no conciliation could be arrived at, the matter was referred to the government of Assam. And accordingly, the Labor Court, Dibrugarh, started the proceedings with regard to the following issues. Number one, whether the management of Murpulani Tea Estate was justified in dismissing the service, the petitioner from service. Number two, whether the workman was entitled to reinstatement with all benefits, including back wages. Next part. The learned labor court, right, the impugned award dated 2/4/2013, passed in reference case number 4 of 2010, came to a finding that the management committed no illegality in dismissing the petitioner from service. And that the principles of natural justice had not been violated. However, as the management were ready to reinstate the petitioner, if she vacated the quarter of which had been allotted to her husband. What have I said? However. No, however, no, not however, just, instead of just before however you say, the learned labor court also held that as the management was ready to reinstate the petitioner if she vacated the quarter allotted to her husband, comma, the petitioner should vacate. No, petitioner was directed to vacate the quarter within 10 days. And thereafter, the management was reinstate the petition. It further held that the petitioner was not entitled to any back wages, as the petitioner was not in service. Next paragraph. Subsequent to the impugned award dated 2/4/2013, passed by the learned labor court, the petitioner wrote a letter dated 12/12/2013 to the Assistant Labor Commissioner, Balaghat, stating that as she was intending to prefer a writ petition before this court. No steps should be taken to execute the award made by the learned labor court. Next part. Today, when the matter is taken up for hearing, this court finds that the affidavit of the petitioner shows that she was 65 years of age as on 3/2/2014, and as such would have retired as a laborer at the age of 16 in the year 2009. So start. The water which the petitioner had refused to vacate, had been allotted to her husband, who was employed as a driver in the tea estate and had retired in the year 2004. The petitioner was allotted a workman quarter with a direction to vacate the quarter allotted to her husband. However, the petitioner refused to obey the directive passed by the manager. In any event, the petitioner has apparently retired in the year 2009. When considering the age given by the petitioner in her affidavit, the above facts clearly goes to show that the petitioner has been in illegal and unauthorized occupation of the water allotted to the petitioner's husband, which should have been vacated in the year 2004. In that way, the matter and the fact that in view of the fact that there is nothing to show that the that any no, in view of the fact that there is nothing to show that there has been violation of any procedure in dismissing the petitioner from her service, this court, not being an appellate authority for the purpose of examination of departmental proceedings on facts, no infirmity can be found in the impugned award passed by the learned labor court. In view of the above facts, further, in view of the fact that the question of reinstatement of the petitioner having been allowed as a good gesture on the part of the management, the same was to be acted upon only after The, only after the petitioner vacated the quarter occupied by her. In view of the continued unauthorized occupation of the quarter of the Murpulani tea estate. This court directs the petitioner to vacate the said quarter immediately. And the management dash respondent shall ensure that the same is acted upon. There being no there be no grounds to interfere. Now, the writ petition being devoid of any merit, the same is dismissed.
Public. Public.
Wait, this petition against the judgment and awarded it 39.
You go, call someone, tell someone to come. No, time, it will take time, I think. Yes, what is this matter about?
This is regarding, I'm challenging an award dated 39/2013, whereby reference was decided against me and the workman. I was temporarily appointed as a sweeper by the SBI, Indian branch, in the year 2004, my lord. And I was allowed to work till 2008.
You were appointed as a workman 2004.
2004. In effect from 29/3/2004, my lord, I was allowed
Huh?
to work as a sweeper.
29,
29/3/2004.
then
Then, my lord, I was allowed to work as a sweeper, and I was also allowed to work as, my lord, messenger in some time. And in later part of 2008, my lord, I was given the additional job of cleaning the ATM booth of the SBI branch. So accordingly, my lord, I was working. Suddenly, in the month of September 2008, the then branch manager of the Indian branch called me up, and he
September 8, 2000,
2008, my lord. September 2008. During
not the date, you don't know the date.
the date, I have the date, my lord. He called me up.
6 September,
16th.
16 September, he called you.
He called
Branch
me up
manager
and
called you.
He said that, my lord, my service is not required, no longer required, and in my place another person was brought in, my lord, and I was not allowed to work after that, my lord. So accordingly, my lord, I raised the dispute, my lord, and the white reference dated 29/4/2010, my lord, was sent to the Industrial Tribunal, Guwahati, my lord.
29 for
29/4/2010,
Industrial Tribunal.
Guwahati, my lord. The reference was, my lord, whether the action of the management of State Bank of India, the Indian branch, in terminating the services of Sri Binoy Kumar Sinha with effect on September 2008 is legal and justified. If not, what relief the workman is entitled. So ultimately, my lord, this reference was decided against me. I will not trouble your lordship to entire judgment. I will go through the evidences, application evidence by the learned tribunal, my lord.
No, what are the reason in short, before going through the entire thing?
Yes, my lord.
What are the reason?
The basic reason is that, my lord, the learned tribunal held that I was not working as a sweeper. My engagement was not as a sweeper, my lord.
I was on day basis for particular.
Daily
work.
wage.
Yes, my lord. And secondly, my lord, I was not work 240 days in a year preceding my termination, my lord. So I was not entitled the benefit under section 25B as a workman. These are the main two grounds by which, my lord, the reference was decided against me.
So let us see your appointment order.
There is no appointment order, my lord. There is no written order. It is an admitted fact, there was no written appointment order. The then branch manager was called me and he allowed me to.
Oral. So there's no appointment order.
No appointment order. I have the evidence I have adduced during the before the landed court below that I have received the wages through cash voucher and subsequently.
Wages to cash voucher.
Yes, madam. I have annexed that voucher, my lord. And subsequently, my lord,
Let us see which page.
page, my lord, page 21, annex A, page 21. 80 case voucher, my lord. Then, my lord,
Just a minute. Page 21.
21.
So you have been paid this. So what does this prove? How much were you being paid?
My lord, initially, my lord, per day 50 rupees, my lord.
50 rupees per day.
Subsequently, it was extended to 60 rupees, my lord. And additionally, for cleaning the ATM boot, 30 rupees was additionally paid to me.
Addition.
Additionally. And regarding, my lord, my service, regarding, my lord, as a messenger, my lord, they paid me, my lord, TA and DA for doing the messenger job. That was admitted position, my lord. They are not disputing that, my
No,
lord.
no, that is all right.
Only thing is that, my lord, there was no written appointment order.
Was there any advertisement? No, nothing.
Sorry, my lord.
No advertisement, no, nothing.
Nothing, my lord.
No advertisement, no selection process.
Nothing, my lord. My only contention is, my lord, I was allowed to work for 4.5 years, my lord. And in fact, in a year, in the year 2006, I was, from the evidence, it is shown that, my lord, I was working.
And for the year
continuously for-
2007, you worked for how many years? How many days?
That is in the
According to
judgment,
the,
my lord.
uh,
My lord, kindly come to page 89, my lord. Page 89. This is the finding of the learned court below, my lord.
yes,
From the year 29/3/2004 to 15/10/2004, 37 days. Then 1/11/2004 to 24/12/2004, 44 days. The total working days is in the year 2004 is 81, my lord. In
where do you get this?
paragraph 11, my lord. Paragraph
Yes,
11.
yes, which paragraph 11 is a huge paragraph.
Okay, I'll
From-
read it out. my lord.
From the middle of where?
Seventh line.
Seventh line, Manu. From
Okay.
seventh line.
It appears that the workman has worked.
Yes, my lord. Then, my lord, for the year 2005, my lord, I was working for 235 days. And for the year 2006, it was 320 days.
Okay, for 2004, you worked for 81 days.
81 days.
And then
2005,
2005,
235 days.
235.
And 2006, my lord, 320 days.
Then 2007,
2007, my lord,
total number of days was not counted, my lord, but per month they from my lord, from 13 to 2007 to
Yes,
28.
how much is the date?
Well, I'll just count it out, my lord.
Both of you count it out. Because that 240 days, I think, this is the year,
Yes, my lord.
the year preceding
It
the,
was found that in some months, they have shown more than 30 days of work from the petty cash.
whatever it is, if you're going to, dismiss him on the ground that he has not worked for 240 days prior to the preceding year, prior to the year of termination, in terms of section 25. And you have to count whether he's the 240 days. there.
The stand of the bank is not that he has not worked for 240 days, that's why he is listed. The stand of the bank from the very inception is that he was not an employee,
He is a daily wager.
he was a daily wager from the very initiation. And initially, he was an employee of uh, of a person who has rented out the generator set to the bank. And he was working under the person who has rented out the generator set to maintain the generator. And subsequently, he was working as a daily wager, so his services were available. Okay. That is the correct. I'm counting the.
And then besides this, for us,
233 days, my lord.
Huh?
233 days, according to my.
233.
Yes, my lord. Uh, 244, my lord. Paragraph 12, my lord, is the categorical finding of the learned court below that I didn't work for 240 days.
But okay, that's for two, but then now it should be actually not preceding year, it should be preceding 12 months.
Preceding 12 months. Because in 2006, I was worked for 320 days.
So preceding 12 months, how many days did you work?
That I have to calculate, my lord, because
Okay, anyway, so
so, my lord, since as per the evidence adduced by me, I was working continuously for 240 days in 12 consecutive months preceding my disengagement. So I am I'm a workman under section 25B. And before terminating me, they have to give me a notice, my lord. That notice has not been given to me.
Do they have to appoint you through an advertisement?
No.
No. Do they have to appoint you through any selection process? No.
No.
Then, do they have to appoint you with any written document? Nothing?
Nothing.
Nothing for you. And everything can be done in the gray area.
Yes.
That's all.
That is admitted to it. There was no selection procedure and there is no appointment order. As such. On verbal excellence, I was allowed to work, my lord. And
No pay scale,
Continue.
only fixed pay.
on a
50 rupees per day.
initially 50 rupees, then it is
60 rupees.
60,
And then-
and additionally 30 rupees for additional work. So basically around 100 rupees per day.
So that makes you a daily wager. And when you're not working every day, for 2004, you work for 81 days. For one whole year, in 365 days,
For
you work for 81 days. For 2005, you work for 235. 2006, you work for 320 days. 207, 244. Preceding 12 months, less than 240.
preceding 12 months, it will be more than 2.
How?
Because I
Show me,
I
show me
was
the-
terminated from September 2008, my lord.
Correct.
So it will be counted from 2000.
No, but then how?
So in the judgment, it was not
Judgment
clearly
has said,
reflected.
judgment has said that he has failed to prove.
Page 22 from last. 10th line from last, from the bills raised by the workman.
Ah.
Right, exhibit 176 to 181, it appears that the workman performed cleaning of ATM for 24 days with effect from 1/11/2007 to 24/1/2008. And in the month of March, April, and May 2008, he submitted bills for cleaning ATM premises at the rate 300 per month each. As such, the engagement of the workman is irregular, and he was entrusted.
Even the industrial dispute side.
Interested to perform different nature of work by the bank on different dates in need of the bank. And the payment was also made on the basis of the work done by the workman as it revealed from the petty cash vouchers, petty cash register, debit slip, paying slip, as well as the bill raised by the workman as mentioned above. The petty cash register also shows that some other workers were engaged by the management for cleaning, grass cutting, etc. in the bank premises on daily basis. So the bank was availing the service of many days, daily wage aggregate from time to time. It was not a regular work.
So you were asked to do, what work were you supposed to do earlier?
Earlier, my lord, I was actually sweeping, my lord. Sweeping, cleaning the bank premises, cutting the grass, my lord. Then subsequently, my lord, cleaning the ATM booth.
Yes. Anything else? Some citation or some?
Yes, my lord.
Yes.
In the case of my lord, Harinandan Prasad and another Prasad, employer to management of Food Corporation of India. 2014 7 is page 190, my lord. For the fact, my lord may refer to the paragraph 2, my lord. The two appellants were working on casual basis with FCI. After a certain time, their services were dispensed with. Both of them raised industrial dispute alleging wrongful termination, which was referred to the central government come industrial tribunal. These proceedings culminated in two awards dated 12 February 1996 and 18 12 1996 respectively, passed by CGIT. In both these awards, termination of both the appellants was held to be illegal and they are directed to reinstate with 50% back wages. CGIT also ordered their regulation in service. So, paragraph 5, Horizontal, he was engaged on daily wage basis as laborer come workman. In my case also, I was engaged as daily wage basis. And in Gobind Kumar Sotimal, paragraph 7, he was also engaged as daily wages as casual typist, my lord. Paragraph 7. And subsequently, my lord, paragraph paragraph 34, my lord. A close scrutiny of the two cases thus would reveal that the law laid down in those cases is not contradictory to each other. In UP Power Corporation, this court has recognized the power of the labor code and at the same time emphasize the labor code is to keep in mind that there should not be any direction of regulation if this offends the provisions of Article 14 of the Constitution on which the judgment of Umadevi is primarily founded. On the other hand, on the case, the court has recognized the principle of having regard to the statutory powers conferred upon labor court, industrial tribunal court to grant certain relief to the workmen, which includes the relief of giving status of permanency to the contract employees. Under statutory power does not get denuded by the judgment in Umadevi case. It is clear from the reading of this judgment that such a power to be exercised when the employer has indulged in unfair labor practice by not filling up a permanent post even when available and continuing to employ workers on temporary and daily basis and taking the same work from them, making them do some purpose which was being performed by regular workers, but paying them much less wages. It is only when a particular practice is found to be unfair labor practice as enumerated in Schedule 2 and it is necessary giving direction under Section 30 of the State Act that court would give such a direction. Subsequently, my lord, in this case,
Yes, taking too much time.
Paragraph 43, madam. However, insofar as applicant number 2 is concerned, he was engaged on so and continued till 5990 when his service were terminated. He even raised the industrial dispute immediately thereafter. Thus, when the circular to so was issued, he was in service, and within few months of issuing the circular, he had completed 240 days of service. The non-regulation of the applicant number 2 while giving the benefit of circular to other similarly situated employees and regularizing them would therefore be clearly discriminatory. On these facts, CCIT rightly held that he was entitled to the benefit of the scheme containing circular to and so. The division bench in the impugned judgment has failed to notice this pertinent and material fact which turned the scales in favor of the applicant number 3. High Court committed error in revising the direction given by the CCIT, which was rightly affirmed by the learned single judge as well to reinstate the applicant number 2 with 50% back wages and to regularize him in service. So in that case, my lord, he was given the benefit of back wages 50% and direction was issued to regularize his service. Because it was found that he was working to 40 days preceding his termination. Similarly, my lord, in the Mansing also, my lord, direction was given to pay the compensation for illegal termination without keeping notice. Mansing case number 2006 7 SC 752. We direct the applicant to pay the aforementioned amount to the respondent within a period of 8 weeks from today, failing which the same shall carry interest at the rate of 6% per annum till the date of actual payment. If this actually is allowed, the extent mentioned here. By not following the procedure laid down in the industrial dispute matter, direction was issued to pay the compensation. So I was appointed as daily wager matter, but under the industrial dispute act, I was in workman matter. So if a workman is terminated from service without giving notice matter, then section 25 F will come.
That's all.
Yes, sir.
I would rely on 2014.
Is he a workman?
No,
Why?
that is our Stanley Lordship. He was
Why-
not properly
why?
appointed.
Huh?
He was not appointed, Your Lordship.
He's not appointed as a workman.
He was not. He was working as a daily wager.
So what about the judgment that he referred?
Lordship, I would like to say.
No, he before that.
Because he has not even placed his appointment letter. There is no question of appointment letter.
No, it's the concept. Going on this thing to what you were saying. Then that judgment that he has relied upon, that Hari Nandan case, 2014. Also, that person was again engaged as a daily wager.
Daily wager. I have to go through the judgment to see whether there was a proper written document for his appointment.
Well, even if there is a written document saying that supposing there is a written document saying that he's a daily wager, then what happens?
Then his continuous service would be counted.
Out here, because there is no document, so he would not be counted.
Even if it is counted, Your Lordship, it falls short of the 240 days on the that Lordship, secretary to the this one, Your Lordship, 2014 4 SCC 769, para 7.
Yes.
Please refer. This court has, the Honorable Supreme Court has referred another judgment, Your Lordship. Rajasthan, State of Rajasthan versus Dayalal has considered the scope of regularization of irregular or part-time appointment in all possible eventualities and laid down well-settled principles related.
No, regularization. Regularization, Uma Devi is there.
Yes, Your Lordship. Uma Devi is there.
Then
Thereafter, it was,
no, his case is not regularization.
he is placed for him.
His case is that he's terminated legally.
No.
He's saying that, huh?
What stand is there? When he was not at all appointed, he was working on as a daily wager from time to time, that is whenever there was a need of the bank. There was no continuous service. That is the stand taken by.
What about this judgment of 2014?
One minute.
Para 5. Yes, what about this 2013 judgment for which para are you relying for?
2013.
You're not relying
Pa-
upon
pa- Paragraph 20 and 21. Now, if the facts of the present case are seen, the position that emerges is this: the workman worked as a work charge employee for a period from 1/11/84 to 27/17 to 1986. In all, he worked for 1 to 86 days during his employment. The service of the workman was terminated with effect from 18 to 1986. The workman raised the industrial dispute in 1992. That is, after 6 years of termination. The labor court did not keep in view admitted delay of 6 years in raising the industrial dispute by the workman. The judicial discretion exercised by the labor court is thus thought and unsustainable. The division bench of the High Court was clearly in error in restoring the award of the labor court, whereby reinstatement was granted to the workman. Though the compensation awarded by the single judge was too low and needed to be enhanced by the division bench, but surely reinstatement of the workman in the factual circumstances is not the appropriate relief. In our opinion, the interest of justice will be subserved if, in lieu of reinstatement, the compensation of 1 lakh is paid by the appellant to the respondent. You order accordingly, such payment shall be made by the appellant to the respondent within 6 weeks from today, failing which the same will carry interest of 9% per annum. So, Manoj, there was a delay in raising the dispute matter for 6 years. So, reinstatement was interfered with by the Honorable Supreme Court matter, and compensation was given in lieu of reinstatement.
judicial judgment with right. Third, Mr. N.J. Kataner learned counsel for the petitioner. Now, Mr. N.J. Kataner appears for the petitioner, while Mr.
PGM
appears for the whom? Appears for whom?
for the statement.
For the SBI. The petitioner who served as a sweeper in the Dinjan branch of the SBI challenges the award dated 30/9/2013 passed by the Industrial Tribunal Party, whereby the termination of the petitioner's service with effect from September 2008 is upheld and 16 September 2000 is upheld and the reference was answered against the terminated work. Okay. Next up. The petitioner's counsel submits that the petitioner was appointed orally as a sweeper on 29th 2004 and worked with the SBI Dinjan branch. The petitioner was given rupees 50 per day as a sweeper. So later, when he was also asked to clean the bank premises, that is cutting grass, etc., he was given rupees 60 per day. So subsequently, the petitioner was asked to clean the ATM, for which he was given an additional rupees 30 per day.
Yes.
The petitioner was also asked to sometimes act as a messenger by the bank, for which he was given CAD. CAD?
Yes.
Yes, sir. The petitioner submits that the petitioner's service as a daily wage worker was, and as a workman, submits that the petition service as a daily wage worker amounted to a workman and he had been terminated from service on 16/9/2008, without any prior notice. The same had to be set aside in terms of section 25,
Yes, sir, 25.
F.
F.
Section 25F of the Industrial Tribunals Act, Industrial Dispute Act,
Dispute Act, 1940.
Industrial Dispute Act 1940. Next paragraph. The petition of the subject, that the petition. The reference brought to the notice of the Central Government Tribunal, some labor court party. Was as follows. Inverted commas, whether the action of the management of State Bank of India, Sinjan branch, in terminating the services of Shri Binoy Kumar Sinha with effect from September 2008 was legal and justified. To stop. If not, what relief the workman was entitled. The award dated
3913.
30/9/30. Passed by the learned tribunal. And the industrial tribunal in reference case number 7 of 2010 was answered against the FL 26 on the ground that the petitioner was a daily wage worker and not a workman. Is it?
Yes.
So the further, he had not been able to prove that he worked under the SBI Indian branch regularly and was paid to be 60 at any point of time. Further, the petitioner had failed to prove that he had worked for 240 days continuous in the 12th consecutive month preceding his termination. In support of his submission of the petition, termination of service should be set aside. The learned counsel for the petitioner has relied upon the judgment of the Supreme Court in Dash versus Dash 2014 7 SCC 19. In para 2, 5, 34 and 46. The petitioner also relied upon, he has also relied upon the case of Dax versus Dax, 2013, 14 SCC 540, para 2021. And in the case of Dax versus Dax, 2006, 7 SCC 730. Next one. The learned process for the SPR. On the other hand, subject no appointment order was given to the petition as it was. No advertisement was made and neither was any selection process resorted to on the basis of which the petitioner had was voting for the FCS as a daily wage. When do we list it?
Last week of February.
Huh?
Last week of February.
You'll be ready, okay? Then this is the matter on. See what this. This is holiday.
25th Sunday. Obliged.
This is motivation. 31.
Lordship pending, with passport pending.
Huh?
That might be another book. Pending consideration. Vote number 7.
Yes, what is your case?
A small issue matter that matter regarding matter the remission of matter excess amount. But okay, matter that settlement was made on matter 2016 for a period of 7 years. And matter the tender was issued in the month of May. And matter finally the settlement was passed matter on the month of July. But matter they are claiming matter that the financial whole financial year. So this is the amount only that
No,
remission of
according to you, they were supposed to hand over the
so it was handed over on my lot 8/7/2015.
8/7 2015, and it was supposed to be handed over on.
They are claiming that Manoj, from 1st of April to 30th, Manoj, the period is from.
You are claiming from 1 April
Yes,
2015 to 8/7/15.
So-
And they are saying that they handed over you the.
No, Mala, they have, this is the admitted case, Manoj. They have handed over on 8/7/2015, Manoj. But they are claiming from 1/4/2015.
Claiming what?
Claiming this for a settlement, Manoj, that,
Okay, so because you were, so you were given this settlement. So,
on a settlement.
so 3 months later.
Yes. No, 4 months.
Huh?
4 months.
No, not for.
Yes, sir. Because no tender was issued in the month of May.
They were supposed to give you on the 1st April,
Yes, sir.
so they gave you on 8th July.
8 July.
So April, May, June.
July. April, May, June, July.
3 months is it's 8
No,
days.
4 months, some 4 days.
How can it be 4?
1st of April, my sir.
April,
April,
May,
June, July.
no, so they gave you in July, they gave you on 8th July. That's what you said.
8/7, my sir.
So 8/7 is the middle of
Yes,
July.
yes. 3
So
months,
3 months, 1 week. 3 months was.
only that period, sir.
Now the issue is it was for 7 years.
7.
From which period to which period?
Actually, up to 2022.
22. So are you still in that?
I am not aware, because
This is of 2015.
yes, sir.
So now probably if you are still there, now you have to pay extra for.
I am not aware. Sir.
Then what to do?
That's it.
So you please ask your client as to how long he was in possession of the fishery. Fishery?
Yes, sir.
Fishery, because you took it on July 2015. Now when did you leave that?
So period is 7 years on, but I am not aware.
22 it would have finished. 22 July it would have finished. Now it is 24. Because this writ petition is of 2015. Where is it? Where is it? It's coming. Is he coming?
In the midst of argument,
We'll wait for him. Tell him to come. Even if after finishing also we'll wait for him. I'll wait for him at least. He doesn't have to be. Okay. Tell him to come.
Wait, wait, wait.
What does this matter?
Fisheries department, they are supposed to protect the record.
My lord,
You will see that first. Okay, what is the matter about?
my lord, in this petition, the petitioners have basically challenged two orders. In this, my lord, just if my lord would allow me to place my lord in brief, but there are two orders which have been introduced. There are two orders. The first order is in relation to, my lord, the illegal extensions made to the concerned fishery in respect of the private respondent who has been operating this fishery since 2014. Now it has been extended beyond the term for which he was given. So,
Okay, so the
7 years.
petitioner was settled with the fishery
in the year 2014.
when?
Yes, my lord. Then my lord may kindly come
When
and
date?
5/11/14.
Huh?
The fishery was settled with the petitioner.
On 5/11/2014.
5/11/14. And it remained status
if I
quo
may
order
be
from the court. There is a court stay order, so he could not operate.
He could not operate.
Could not operate. So therefore, lastly, by an order dated 29/10/2019, my lord, he was settled for that up to that period, my lord. He was given settlement from 7/12/17 to 4/11/20.
My lord, there are a lot of intervening periods.
7,
and I may
12,
allow-
17 to
4/11/21. That is that 7 years covered. And thereafter 3 years.
so 21. So it has finished.
Finished here. Thereafter, they have given 3 years extension.
Here's extension. So
After-
it will end in 24.
And 24 November.
On what ground has they given you extension?
My lord,
Can you say there is a provision for giving extension?
3 years.
extension provisions are there, my lord, but our cases, my lord, this
Your lordship will see the
settlement which was granted to my learned senior friend's client was basically granted without giving even a due regard to the order in the first round of litigation, which was miserably lost by them. His settlement was set
Okay,
aside.
just a minute. I think it will take some time.
Yes, man, of course, it takes time.
It will take some time.
Take time, sometime.
So we'll discuss when,
On a convenient date, as my lordship.
right? On the parties list the matter, give a date. It takes some time. Not very much. It won't take very long, but
Long time, my lord.
it will not take very long. It's just that you will argue a lot. That's all.
Whether they have.
Whether it justified
Huh? 20th February
2820.
20.
I'm deeply obliged.
20 is the
My lord, we have some urgency in the matter, ma'am. Let it be on 20th.
20.
I'm deeply obliged.
Filed or it is certificate. Today, my lord.
Yes, yes, check. Yes,
I'm obliged.
Let me 24.
Yes.
yes, he's,
I was in
Huh?
in the midst of an argument in court number
no, he is asking for remission for 3 months. On the ground that the fishery was to be handed over to him on 1st April 2015. But it was handed over to him on 8 July 2015. Now 7 years expired in 2022. Now I want to know, when did he leave the fishery? because his case might, most probably might not have, thing, and he might have been given extension also, we don't
No,
know.
it was not given extension, Lordship. Normally we do not give extension, Lordship.
Ah.
But nowadays the system is very
And
different.
we have given him 3 years. This BD that, BD. The previous case,
Lordship, yes,
they have given 3 years extension to him.
Lordship, history matter, Lordship.
Ah,
I was in the department of, this is the corporation matter. This is the corporate, I was in the fishery department also, that corporate. Here, Lordship, giving extension is against the, now,
okay, anyway,
nowadays, Lordship, here, this is pre-2022 matter. Lordship. Earlier, these things happened. We have suspended 2 MDs and given cases in vigilance, CID everywhere, Lordship. For this reason, Lordship, for giving giving direct settlement, giving extension, these things. Lordship. Nowadays, we never give. And regarding this part, Lordship, his presentation, if it is right, if he is given after 3 months position, then we may consider it, Lordship. We do not have this
no, the thing is that the term ended in 22.
Lordship.
So what is the status of this case? Because you see, his period
Might
was
have
for
ended,
7 years.
Might have ended.
It has ended. In all probabilities, it has ended.
Ended, Lordship.
It was supposed to be from till March 22, 31st March 22.
Yes.
So fishery was to be given to him on 1st April 2015, but it was given to him 3 months later. So he's saying, give me that money, the 3 months that I could not use the fishery. But the problem is his petition has been filed in 2015. So that period of 7 years ended in 22. What has happened?
I may take the instruction, Lordship. Otherwise, Lordship want to dispose it, Lordship. We can dispose of his application by giving a fresh application. New MD is there, Lordship.
No. Wait.
Nothing is.
Oh, how is that?
Okay, I will take it. I will give the.
You plain instructions.
Okay, may I pray, Lordship, for giving a copy also. I do not have.
Although if that if my understanding other complete just for
Huh?
if my understanding complete that
Proceeds what?
what regarding my that if this excess amount has been returned by us, then it will be refunded.
No, we don't
No, I
know
can-
the fact. He
That's
doesn't
what I can-
know.
I cannot say that I will be refunded, Lordship. I can say that this presentation may be disposed of. That's
No.
For the second half of again the second.
Correct. So no representation. So you just take instructions as to whether any concession was given to him. First of all, whether it is correct or not. Because wait a minute. Mr. Sharma, learned counsel for the respondent, disputes the aforesaid statement made by the petitioner and submitted that the possession of the fishery was handed over as per contract agreement and on due date.
Yes, that agreement on page 22, not 87.
no. There is a.
So that is the Mr. A.K. Sharma. Who's Mr. S. Sharma? Who's S. Sharma?
That's the
I understanding on.
Ah.
I am peace on.
So he has now, so I forgot to read this. There is the order. He has disputed what you have said. He said that it has been given on the correct date,
I mean,
I have annexed that on the page 20,
page 22.
base.
page 22. Second paragraph. The agreement was made on 8/7/2016.
Anyway,
Okay.
okay, right. Heard Mr. A.K. Sharma, learned counsel for the petitioner. Mr. M.P. Sharma, Mr. P. Sharma, for the respondent, submits that he will obtain instructions as to whether the petitioner was handed over the possession of the fishery on 1/4/2015 or 8/7/2015. In view of the contradicting stance taken by the parties in the earlier order dated 23/12/2015. So just you bring the records, that will show everything.
What time was it? 2015 matter, some of them matter.
No, you see, now the only thing is that it's a question of fact. Now, if you bring instructions only,
Look, I will,
but then he will dispute it. He will say that this agreement is there. Agreement is made on 8 July.
it's okay, then not to give a date of after 2 weeks. Okay. A date may be given or after 2 weeks. Okay. Because searching this, many documents is being seized by the vigilance and PI. Many files.
Settlement order was issued on 6/7. So,
Huh?
settlement order was issued on 6/7.
6/7.
Yes. So, how the same vendor.
How can it, how
Yeah.
settlement order issued before agreement?
Yes, my lord. Yes, my lord.
So how do you know possession might have been given prior also?
So 6/7, my lord. And tender was issued on 18/5, my lord. How they issued 1/4?
Huh?
Tender was issued
No,
on
the fact is
18/5.
that initially our stand was that, corporation stand was that, we used to give settlement from the March to March. Lord.
Yes, yes.
That is our stand. While
April to March.
March to April, April to March. April to March, 1st April to March 31st.
31st.
That is our procedure. So we normally what is our stand or if we give settlement in say August also, we ask the parties to okay you take it this from this way. This way they used to concede for this all this.
He is not perfect.
But he has signed it. In the agreement he has signed it.
He signed from 8 July.
Agreement was made on 8th.
But here, Lordship, I think it is not the whole documents. One first page was not annexed. It will be there. It will be there from 1st April. So it's yeah, we have to go. The first page are not annexed. Lord. Here, agreement.
Oh, where? Page?
Page 26. Lord, SMS version. Lord, yeah, they have translated only
Yes, where is the first page?
here in the first page. It is there. The agreement was signed here. Lordship, Anugrah Pandit,
Okay,
in the SMS version.
My lord, annexure 3 page 25, my lord, 8/7/2015. Vernacular, my lord.
This is not the first
25.
page. This is not the first page.
Yeah, 8/7/2025. Agreement was made on 8/7/2025.
So 25, how can it be 25? We're at 24 now.
15, my lord, 8/7/2015.
Here it is clearly written, Lordship, because not, I think I did this translate it.
25.
From the vernacular, I'm translating it here, Lordship, meanwhile, first party has taken the settlement from 2015-16 to 2021-22.
But when? Date? 2015-16 is 1 year. Why should it take 1 year to take over the picture?
That's what it is.
Maybe
I have to bring
2015-16.
record, Lordship. Yes, I have to bring record.
Can I check
Instead of-
that? Mr. MP Sharma shall produce the report on the next date. Leaves the matter on.
After 2 weeks.
Leaves the matter to.
Highly obliged, Lordship.